Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. Joining me on this stream is Charlotte on the web. Hello, Charlotte.
Hey, nice to be here. Thank you for inviting me.
You're welcome. And we were originally here for the purposes of listening to a hearing in the Todd Chrisley, Katie Joy Paulson issue. But Katie Joy Paulson, at the last minute, gave notice at least of her intention to withdraw her motion to dismiss, and so the court canceled the hearing, which actually was slightly surprising to me, because since it was going to happen anyway, I thought maybe it would just turn into a status conference or something like that. But the court decided not to do it, so caught me slightly by surprise. They didn't do something, but okay, they had other things to do with their time, other hearings, and so get a freebie. Why not? That makes sense too. So we won't be discussing the Todd Chrisley case today, although I guess we can, to the extent that you want to ask any questions or clarifications from, we can talk about anything to the extent that, it comes up. But we're here mostly to talk about the 7M case, 7M Films. This is a case involving a talent management company / church / cult / something, which made a complaint against Katie Joy Paulson for a bunch of very specific complaints. And their defamation read pretty well to me. So I was unable to really cast an opinion on surface level, because unlike so many of these cases where I read it, I'm like, this doesn't make sense, or sometimes even, this seems crushing. I don't know how you can beat this. I read this, I'm like, well, this seems solid. It looks good. At least to my mind, the tortious interference claims were not greatly presented, but maybe not as the deal breaker, but could have been a little better in that aspect. But the defamation stuff was really, really good. And so I was like, well, I can't really cast an opinion on this until I read the response. So now we're going to read the response. So hopefully at the end of this,
Good.
I'll be in a better position to render an opinion as to where we're going. So we'll see.
Great.
Nate Brody wants to join?
Oh,
Do you know
Nate.
Nate Brody?
Yes.
Okay, hold on. Nate Brody wants to join. I have to dig this up. Okay, I know how to do this. Hold on. There's another way for me to do this. Ha ha ha. Anytime. There we go. There we go. Send this. Oh, is that the right one? I think it is. Yep, great. Okay, so Nate Brody has it, so he may be joining us. Fantastic.
Great.
All right, so we're going to read this and try to, and we'll see if Nate joins. We'll do another minute of banter, just to give him a minute to join. So, what were your overall impressions reading the response?
Well, first, let me say this. As far as Katie kind of pulling this last minute with Todd Chrisley, doesn't surprise me. Only because I think she knew we were all waiting on it. So that doesn't surprise me.
I mean, she says she wants to do counterclaims, and I was thinking about this in terms of what these counterclaims could be. And the most obvious to my mind, although I obviously can't get into her head for sure, but the most obvious to my mind would be Todd Chrisley's suggestion that she didn't get the information from Lindsay, right? That was not a valid source of information, and that they weren't friends, they didn't talk, those kinds of statements. And so, and I've understood that Lindsay Chrisley was going to be filing complaints as well, and that seemed to be the most obvious basis for a complaint there. And as concerns Lindsay Chrisley, I thought that complaint would be a lot better than Todd's complaint for technical reasons, of course. But if that's where Katie Joy Paulson is going, if she's going to try to go on the offensive of, yes, I did get this information from Lindsay, yes, we were friends, yes, she gave me whatever, if that's her basis for counterclaims to try to countersue for defamation, then that'd be an interesting fight, I would imagine. So that's the most obvious place it's going, because I can't really imagine off the top of my head what else there is, but maybe I'm not imaginative enough.
Will insurance pay for counterclaims?
I mean, again, it's all over the map in terms of insurance.
Right.
But yes, probably the answer is no, because she's not being in a defensive posture. She is trying to go actively against them. So the extent to which those costs are severable in some sense is a whole nother question. But I would think she'd have to pay her own way for at least, the lawyer's time for the motions that she's filing that are not responsive to the claim against her. Nate, the lawyer, is here. as he puts on his ears. Hello, Nate the lawyer. No, not so much with the sound, Nate. Try again. Keep trying. No, I heard something click, but it didn't. There's still no volume. Oh, there it is. There is volume.
Yeah.
Okay, yay.
Hey, Nate.
Charlotte, what's going on? How you doing?
I'm good. How are you?
I'm doing all right. First time on stream with you, even though I watch like all your shows. I'm like a Charlotte Web fan, and now I know you get like 800-900 people watching. I'm like, damn, Charlotte's
I know.
blowing up like a bomb. Yeah.
It's been crazy lately.
Yeah, it's amazing. It's amazing. So Katie Joy is still the bane of your existence.
Unfortunately, yes. The gift that keeps on giving.
I know. I feel bad because I brought my brother Uncivil Law into this whole mess of the Katie Joy.
This was your suggestion, Nate.
And it worked out.
You introduced me to all this. Thanks, Nate. That's great.
But you know, it's weird because this is one of the few times where most of the cases that we obviously me and Kurt have looked at from Katie Joy don't really seem legally don't have the legs that most people think they have. But the fact that there's so many, I think is just going to bankrupt her. It's just too many, and especially, and these are all intentional torts too. So she's coming out of pocket for a lot of this stuff.
One would think, one would imagine.
Wow.
I mean, she at least called, as I mentioned on my own channel, she at least messaged me to say that she didn't believe it was true, that she thought her insurance would help protect her. So I was like, okay, well, I don't know whether or not that's true, of course, because I can't read her policy.
Yeah.
But, you know, I kind of hope for her sake it's true because, you know, I mean, as Nate says, like up to this point, the lawsuits against her have been kind of questionable at best. This is the most promising one I've seen on its surface.
But 7M?
The 7M is the most promising one I've seen. This is the most promising one I've seen on its surface so far. And so I've sort of discounted Todd Chrisley. You know, we had the issues with Toddy. I had other ones, but I was like, I read this and I'm like, okay, this is a lot of specific stuff. This is a lot of ground to protect. She might be able to get to where she needs to be. And so if she can, then, you know, great. And we'll assess from there. I mean, it wasn't like so obvious from reading it that I'm like, this is a slam dunk. I don't see how it can possibly recover. And it wasn't the garbage where I'm like, there's no way this will work. I'm like, I'm somewhere in the middle ground. So
and that's when you go to trial, and that's where the money starts really driving in, right?
Well, maybe we'll go to trial, maybe not, because maybe her motion to dismiss is really, really good, and maybe it will convince me that she has the winning side of the argument. So we'll see.
Why would she wait and withdraw that motion like at the last minute? You know, why would she pull this little stunt today? Do you think that's a good idea?
I mean, the court probably doesn't care one way or another. And she got another 20 days out of it, so there's that. So
that's true.
Yeah.
Well, right now I know for the Chrisley case, she's in a motion to dismiss, and Chrisley's trying to do discovery, which makes listen. I understand there are a lot of people here who don't like Katie Joy. I'm with you, right? Solidarity, brothers. But
I don't ever have strong feelings one way or another.
But I'm talking about, you know, most Katie Joy is not loved at all. As a matter of fact, I've got my beef with her, whatever, right? And I try not to even mention her or the other guy, Steve. But in this context, what Todd Chrisley's trying to do with this discovery before motion to dismiss is really unheard of in the legal profession. And my brother-in-law, Uncivil, can speak about it. And what I mean by that is that the motion to dismiss is a term when you file your case, and this is just so everybody understands the process. When you file your case, you say, this person did this to me. This person can come back and say, well, you know what? If all that stuff is true, there's no remedy under law, right? So if everything you're saying is true, then there's no remedy. So, you know, so there's really no case here. And that's what this initial motion to dismiss is essentially saying. That, hey, even if everything Todd Chrisley's saying is true, then he still loses. So essentially at this stage, Without a Crystal Ball is conceding all of the facts and saying, put it also in the best possible light for Todd Chrisley. So even I'm going to concede all the facts and any ties or any inferences, give it to Todd. Say whatever Todd says, give it to Todd. And if everything he's saying is true and he gets the best favorable inferences, he still can't win as a matter of law.
That's kind of what I thought.
Yes. So what happens is now Todd Chrisley is trying to run up without a crystal ball's legal fees. So the way you do that is you go to discovery, but you can't get to discovery until you survive the motion to dismiss. So that's kind of where we're at right now, where Todd Chrisley wants to kind of backdoor. In no case can you get to discovery before you survive the motion to dismiss.
The odds, the discovery happening while a motion to dismiss pending is so odd, because you sometimes can get limited discovery ordered by the court, but not until they initially consider the motion to dismiss. So the fact they're trying to do discovery before that is I don't even understand how that's possible.
The limited discovery for the motion to dismiss, I've seen before. I saw that in Sandman. There's a couple of cases you can see.
Well, again, as I just said, sometimes you can have limited discovery, right? Sometimes you can have limited discovery for motion to dismiss, but still, you don't get that until after, they at least read the motion to dismiss, and they have a little argument about it. It's okay, we'll order some limited discovery to do that. So that's possible, but we're not there. And by the way, the reason, incidentally, I said with the 7M case that maybe her motion to dismiss will be so good that she'll win is because while Nate is correct that we have to assume every fact she says is true, courts will often consider affirmative defenses. So to the extent okay, you just don't have it as a matter of law, and so here's a whole bunch of facts, and so courts will sometimes consider affirmative defenses like that. So that's one of the reasons I say she might be able to win. Maybe she can show enough evidence in her motion to dismiss that she's well, even assuming every fact they say is true, here's some facts that don't contradict their facts, incidentally. So here's some additional facts that support a legal defense I have, and you can consider that on a motion to dismiss. So that's one of the reasons I say, well, maybe she's got it, but I don't know till we read it.
True.
So let's go ahead and get started with this.
Yeah, let's definitely get started. But one thing I also just want to mention too is that some people may not understand when we talk about discovery, motion to dismiss. So just so we can all understand the language, just the process here. Remember, in the Toddy case, Toddy's case was dismissed for lack of jurisdiction, more essentially saying you're in the wrong court. You have to file it in the right court. Now, just imagine if they went to a whole discovery phase just to find out they were in the wrong court. And then all that goes back, and then you got to go file in the right court, right? So that's why the motion to dismiss it's kind of just saying we're not going to waste your time to go through discovery if you're in the wrong court, if you don't have a case, that type of thing. So that's kind of why the motion to dismiss is like that. But I'm sorry about taking that, but I want to make that point clear.
No worries. So this is the memorandum of law in support of defendant's motion to dismiss from 7M and Katie Joy Paulson without a crystal ball. So we'll read this and see what it has to say. Plaintiff 7M Films is a talent management agency representing influencers and other internet and television personalities. And Robert Shin, the CEO and sole owner of 7M Films and pastor of the Shekinah Church, and Miranda and James Derrick bring a suit before this court based on statements made by multiple media outlets about the alleged cult-like environment created by plaintiffs and that environment's impact on 7M clients. These reports have been published by media outlets such as Rolling Stone, the Daily Mail, the Daily Beast, as well as family members of 7M and a myriad of other YouTube outlets. But now, in general, maybe. But again, there's a lot of specific stuff from 7M, so I don't think this generic is going to work unless she gets into the specifics.
But generally, too, that this wouldn't work because, let's say if I defame you, just because a whole bunch of other people defame you too with using the same statements doesn't mean anything, right? This is about what I said, not about what everybody else says. It could hurt the reputation piece of it, but it's not going to hurt whether I defamed you or not, because so what? If all these other people defamed her, then they may have suits against them. So
this is true, but also as we're considering the mens rea requirement for defamation, which is either negligence or actual malice, depending. The fact that you have, reasonably credible sources like the Rolling Stone, which, we can debate whether or not they're reasonably credible because some of the stuff that 7M, some of the stuff Rolling Stone has put it. I'm looking at you with the fake sexual assault allegations in the college at Virginia Tech. Rolling Stone looking directly at you for that complete crap report. But these are generally, this is generally perhaps good information. So it may go to impact the degree to which she can be deemed to be negligent. So that's Can I ask Charlotte just a quick question? This 7M lawsuit, did you see it coming, and how did you feel about it when it first hit?
I did see it coming. They had pretty much warned her. You continue to speak about us like this, we're going to sue. She didn't listen. She never listens.
Amen to that.
Someone said it was UVA. Was it UVA instead of Virginia Tech?
Hey, man.
Oh well, maybe my memory's slightly off. The defendant, Katie Joy Paulson, is a journalist focusing on celebrity news and entertainment stories. Among innumerable other items she's reported on the past year, Paulson has reported on first-hand accounts of personal experiences of dancers and influencers who formerly worked for plaintiffs based on information Paulson has received directly and through other media outfits and court records. Yet the degree to which she has personal testimonials from people who were involved in this is sort of like a classic kind of reporter thing. You know, I want 2 sources, I want 3 sources that kind of say the same thing, and validates that this might be sufficiently reliable for me to report on. So to the extent that she has first-hand information, maybe, but she'll have to get more specific into that.
Yeah.
Due to total lack of substantial statements provided by plaintiffs in their complaint, what? The mere parroting of case law without facts supporting its application, plaintiffs complain inability to overcome protection against liable suits afforded journalists covering public figures. Journalists don't have special protection. Stop pretending they do.
Yeah.
And the fact that most of the complained of behavior simply consists of statements that are true of opinion. Okay. I don't think you are sex traffickers. Qualifies as a matter of opinion. But all right. Paulson brings this motion to dismiss the complaint. He asserts they should be dismissed for failure to state a claim upon which relief can be granted. Okay, sell me. Plaintiff is the owner and CEO of 7M Films. He's a pastor at the church. They're all publicly known, objectifiable facts. Sure, no problem. I'm sold. You're illegal. She's a resident of Minnesota with a YouTube channel of 186,000 subscribers. Her views have generated 88 million. Sure, fine. In her career as an entertainment and celebrity journalist, sure, why not? Paulson has covered allegations regarding plaintiffs, their business practices, and treatment of managed talent, as have many other media sources that cover similar material. A cursory review of state and federal dockets in which other media sources are headquartered indicate despite similar coverage, the word similar here is key to this, because again, to the extent that she's making, statements that have never been made before, she obviously can't rely on, well, Rolling Stone said it too, or Daily Mail said it too, to the idea of trying to defeat her mental state if she's the first one who said it. She can't rely on things they didn't say. So then she has to go to, well, I have direct firsthand sources, or I have other ways of getting there. But, yeah. Despite similar coverage, none of them have been sued by plaintiff for defamation, libel, or any similar torts. Well, maybe that's because their statements, while somewhat similar, maybe not so much upon examination. Okay.
Yeah, but you don't have to sue everybody who's defamed. You got to.
This is also true. This is also true. You do not have to sue everybody. This is true. Plaintiffs that fail to state a claim upon which relief can be granted must be dismissed. A motion to dismiss the test of legal sufficiency of a complaint. When determining a motion dismissed, the court takes the facts in the complaint as true. Of course they do.
Oh, we've read through all this. Like we've literally
you want to skip that?
The standard,
they're not bound by legal conclusions.
The jurisdiction.
Blah blah blah.
Yeah.
All right, fine. We all know the legal standard. Let's skip on. On a plain reading of the typical defamation standard applicable to interactions between two ordinary private individuals. Well, if they're truly private individuals, then we're into negligence, right? Because then we're not in the public figure. You can't have it both ways. Plaintiff's complaint may hold water by these, if not for the fact the alleged statements are true. However, it's not the case of one simple disagreement between two private individuals. Rather, the parties consist of, one hand, a well-connected talent management company whose role in representing influencers and other media personalities is specific to be put in the spotlight. The influencers, yes. The media company itself, I'm not so sure. And a CEO who's not only a public figure for his in-profit business dealings, I'm not convinced about that at all, but also a pastor of an international church. Do they really have, she thinks they have, congregations of the same church in other countries? Okay. And
but hold on, the public figure thing, though, I don't think it's just so easy to dismiss. 7M is big enough where, for instance, if I get sued, I'm a public figure. I think if you or Charlotte get sued, you guys will be public figures because of the, you guys got 50,000 people watching you, or whatever the number is. So it's not like it's not so easy to win. I think you have a fight here with the public figure status.
I'm sure you have a fight, but I don't think it's a give me. And the reason, I at least the question would be, is 7M, if they purposely avail themselves, are they as a company, well known? And I don't think the mere fact they're a public company does it for you. There's a lot of public companies who are kind of media shy for whatever reason, so that doesn't do it for you. So you'd have to show some evidence, to my mind, that would indicate that they have, done this. I'm not taking it as given. And also the CEO himself. Like, if he's just because you're the pastor of a church does not, in my view, make you a public figure. Because again, it can be kind of a closed congregation, or even if it's international to some extent, it doesn't mean that you're like making, purposeful availment of the media. So I'm not sold as an automatic.
I'd like to, Charlotte, because you said that this was coming. How do you feel about 7M? Just as a non-lawyer, do you think they have enough presence where you can kind of consider them to be a public figure in that sense? Just somebody who's looking for the public's attention.
No, I had no idea what Robert Shin even looked like until Katie dug for a picture. I've seen one picture of the man.
Yeah.
Okay.
So I mean, we might be able to get there, but I'm definitely not taking it as given, like I have in some cases.
Todd Chrisley, it's a given.
Todd Chrisley is a given.
Yeah.
This show is called Chrisley Knows Best. It's about him. That's purposeful availment. No problem.
Yeah.
No problem. We could even have a debate if we really want to about other people on the show. But Todd Chrisley, he's literally the focus of the show. It's his show. It's named after him. He's a public figure. No problem.
Yeah.
In this case, the plaintiff cannot merely rely on common law formulations or defamation or the Minnesota Supreme Courts, because the Minnesota Supreme Court does not address the application of principles, either to members of the media or to public figures. Again, I don't think members of the media are special.
Yeah,
Under the relevant law, the element of standard defamation cause of action required the statement is false, communicated to a third party, intended to harm the reputation. And also, what are we missing? The mens rea element. Unless, of course, Minnesota doesn't have it in a strict liability state, which seems unlikely, but okay.
That'd be a constitutional violation, though. So
it probably would, I would think. But some states, I think, do technically have some strict liability defamation. But, it could be an issue. While the case law is useful in providing guidance on the question of whether a defendant made statements with actual malice, we need to look to sources for application of defamation standards. Because the source of law applicable in Minnesota provide an increased burden for a plaintiff alleging defamation by a journalist, do they? I really hope you have specific citations to that. And if the plaintiff is a public figure, they cannot meet the standards. Okay. Sell me on the fact that in Minnesota, members of the press have special protections. Sell me.
I'd have to look that up.
I'm not buying that.
But this is the part that I always, with Katie Joy, she doesn't understand. Well, I'm assuming her lawyers understand. She would be more protected. This whole journalist thing. Mm-hmm. It's like they have the same protections as everybody else, right? You can't defame somebody and just say I'm a journalist, right? So this journalist protection doesn't really mean anything. And on top of that, she would be more protected if she wasn't a journalist. Let's say if she said, I'm an opinion show, right? Like Tucker Carlson or Rachel Maddow.
Yeah.
She would have an extreme measure of protection. So the fact that she's going into this I'm a journalist piece actually removes all that protection, because
this is a fair point.
Yeah, because it's like she can go on Tucker Carlson and be like, yeah, I'm new Fox News, and then have an opinion show.
This is right. Rachel Maddow and Tucker Carlson basically went with we're not journalists. Yeah, I don't know why no one would think we're journalists. We're opinion shows. Everyone knows we're opinion shows. No one understands us to be reporting fact, and so forth and so on. And these defenses were effective for Rachel Maddow and Tucker Carlson for that reason. So yes, Nate is right. Her calling herself a journalist implies that she's reporting actual facts.
It hurts.
And so there's that. So she loses some ground of protection. So, yeah.
That's why I'm not understanding why she keeps going through this journalistic thing. It's like, what are your lawyers just not understanding that?
Yeah, I'm not sure about that one.
Yeah,
and
that's the hill she's choosing to die on.
You're not gaining anything for it. I really hope somewhere on this she's going to cite something that says journalists get more protection, because if that exists, then fine. But I want to see a citation or something. In the landmark case of New York Times versus Sullivan, this is not going to do it for you.
This is not
the United States Supreme Court adopted a new set of constitutional protections for publishers of information relevant to public discourse. Yes, that's publishers.
Not true. Yes,
all them.
But I think she's thinking publisher as a newspaper.
No.
And the thing is, publisher in this context means anybody who delivers the information to third parties
Correct.
is a publisher. It's just not
Yes.
newspapers.
Correct. Right. Libel can claim no talismanic immunity from constitutional limitations. It must be measured by standards that satisfy the First Amendment. True.
Sure.
The general proposition that freedom of expression upon public questions is secured by the First Amendment has long been settled. One would imagine.
Mm-hmm.
Authoritative interpretations of the First Amendment guarantees have consistently refused to recognize exception for any truth of test, whether administered by judges, juries, or administrative officials, especially one that puts the burden of proving truth on the speaker. The constitutional protection does not turn upon truth, popularity, or social utility of the ideas of which is being offered. I mean, this is ultimately true when you're talking about opinions, right? You can have any opinion you like, and, it's fine. Minnesota has adopted the holdings and consequences of this in Minnesota law, which, they kind of had to.
Well,
Agreeing that
absolutely no choice to, right?
kind of had to do that. Agreeing that states of libel that fail to provide safeguards for freedom of speech in the press guaranteed by First Amendment of the United States and are made applicable to states of the 14th Amendment are constitutionally deficient. Yes, this is just what the Supreme Court just said. So, wonderful. They went on to hold a number of things produced by the Supreme Court in New York Times.
Well, can I? Well, before you go into that, can I ask? That's Charlotte. Now she's going into this. I'm a journalist. Sometimes in Toddy, she kind of said she wasn't a journalist, but she was a journalist. So are we back to I'm a journalist again?
Yes, yes. We are a journalist again.
Oh my God!
Not a commentary channel. We're a journalist.
Yeah, you can probably take different positions from case to case, but you can't really take different positions within the same case.
Yeah.
So it's like once you claim one of those things, you're kind of stuck with it, because if you try to go backwards and try to change it, you're going to have a bad time. Yeah. So you're probably okay claiming it or not, but once you do, you're kind of stuck with it. So here are some holdings apparently. First, public officials and other public figures are subject to vigorous attack, including under some circumstances, defamatory and untruthful attack. Second, the privilege of defamation attack is applicable to public figures, even though such figures are not public officials. Yes, correct. This is true. Mm-hmm. All public persons, which, might mean New York Times versus Sullivan went too far, but that's another discussion for another day. Third, the meanings of actual malice stated in the New York Times, although not fully articulated in subsequent decisions, have been given a term, at least in what it's not. What the New York Times rule ultimately protects is defamatory falsehood. No matter how gross the untruth, the New York Times rule deprives a defamed public figure of any hope of legal redress without proof the lie was knowing one or utter disregard. This is the thing we've long since quoted about actual malice. That's what actual malice means. Actual malice has nothing to do with malice.
No, it has not.
It's just poorly named.
But
it has nothing to do with hatred or dislike. It has nothing to do with malice.
No, but this is where I think she undercuts her argument, because to prove actual malice, right, you got to prove the person knew it was false.
Yeah.
And said it anyway. But also a way to kind of get around malice, which a lot of lawyers don't talk about, is if you made it up. Because if you made it up, then you know it's false. So the problem is with Katie Joyce saying she's a journalist, she's saying that, hey, I didn't get this from these sources. I said this myself. So if they're false, and it's going to be like, well, you just made it up, and automatically giving you actual malice. So she has so this is why, again, this is her legal team writing this up, but that's the reason why I wouldn't have gone with this journalistic stuff. I think this journalistic stuff is for you, Charlotte, because you probably be making you and the cat guy and everybody makes fun of her, our favorite journalist. And she's like, yeah, I'm gonna go over like a journalist. But I think this hurts her case, because she's saying I'm putting out pure facts, and now you don't have to prove the actual malice piece, because you're telling us you're putting out pure facts. And if they're not facts, then you had to know they were false.
Yeah.
Maybe. I don't know if I go that far, but I think your argument towards that end is good. Yeah. I don't think you can get all the way to the end, but I think you're making that conclusion more likely by that claim. So I'd agree as to that much. In addition to Minnesota's adoption of New York Times line of cases, reporting on statements made by law enforcement is specifically. I know this. This is fair report privilege.
Yeah.
If you're reporting on something the government says, as long as you're fairly characterizing it, which is a big caveat, then you can't be sued for defamation, because everyone has the right to talk about what the government is doing.
Yes.
And so, you can talk about it. If they made a mistake or defamation, sucks to be you. Go sue the federal government, and good luck with that, In addition to Minnesota's adoption of the case, reporting on statements by law enforcement is specifically protected for journalists. No, it's not. It's protected for everybody.
She's with this
In
journalist
Minnesota
thing.
via the fair report privilege, stating that fair report privilege applies to fair and accurate reportments of statement by law enforcement, and fair report privilege protected fair and accurate news reports about a press conference and news releases. Yeah, what does that not say?
For law enforcement,
What does that not say? That you have to be a journalist
Yeah.
in any way. It doesn't say anything even remotely close to that. It applies to statements by law enforcement. It applies to press conferences by anybody. Summarized in the Minnesota Supreme Court analysis, the court highlighted the court's reliance on the Second Restatement of Torts, which is a very good treatise, we call it, or sometimes called a hornbook if you're real old, which basically these are books that summarize all the law on a particular subject and are very, very good. And the Second Restatement of Torts in particular is very good. It's a big fat book because it summarizes all the law, but it does a good job.
Most people don't realize that torts, contracts, and there's some other ones are purely common law fictions. In other words, there's really no statutes in those areas. So you'll even see, well, some states do have statutes, but most states don't. They use the common law principles. And the Restatement of Torts is kind of like the universal Bible. So you'll see a lot of courts in tort cases, they'll go to say, okay, in the Restatement of Torts, second edition, this is what it says, and we're going to make our ruling based on that. So that's what kind of the Restatement of Torts is. It's taking those common things that are not statutes from the legislature, but common law principles, and puts them in a book to make it easy for judges to make rulings on.
Yep. Which states the publication of defamatory matter concerning another in a report by anybody of official action or proceeding or of a meeting open to the public that deals with matter of public concern is privileged if the report is accurate and complete or a fair abridgment of the occurrence report. It has to be fair. Similarly, the Minnesota Court of Appeals has stated that newspapers have a qualified privilege when making a fair and accurate report of public records. First of all, I don't think it's exclusive to newspapers. Second of all, even if it was, K. Joy Paulson, you were definitely not a newspaper.
And we're talking about public records too. I think they missed the public records part.
Yeah,
public records, police reports.
By public records, we mean governmental records specifically.
Yeah. They kind of missed that.
That's what we mean by public records. We mean governmental recorts.
But quick question, Charlotte. Is she pointing to any like government documents with her defamation? Well, no, I'm gonna say alleged defamation of 7M.
We're gonna find out, I guess.
There was a lawsuit filed against Robert Shin 14 years ago. And from my understanding, he ultimately won that lawsuit because he was considered a church and the courts didn't want to intervene in that. Mm-hmm. But she highlighted a lot of the points that the plaintiff, Lydia, had made, and she's presenting that as all fact, even though Robert Shin ultimately won the lawsuit.
That could be problematic, yeah. That could definitely be problematic because that's not fair reporting then. That wouldn't be fair reporting.
Absolutely.
Without the conclusion, yeah.
All right. Many of Paulson's recitation of the complaint materials drawn from public court documents. Okay. Regardless of the light in which those statements paint plaintiff, and regardless of whether plaintiff agrees with those statements, they're privileged against claims of defamation and thereby bases for cause of action. Well, this gets tricky. And I don't actually know 100% what the answer is, and maybe Nate knows better. Because if you're talking about something written by the court, sure, you're there. Mm-hmm. If you're talking things filed by the attorneys in the courts, the attorneys themselves in their documents are protected by litigation privilege.
Yes. But
to the extent that you're even fairly quoting that stuff, I don't know the degree to which you'd be protected. My first impulse would be to say, I don't think you have any extra protection versus any other document, but would you disagree with that, Nate?
I would disagree with it for the aspect of if someone's alleging something in a lawsuit, and this is an ongoing lawsuit, like the Johnny Depp lawsuit that we've recently been looking at, you can repeat the defamatory allegations as a fair reporting privilege, but as long as this is what's being alleged and so forth, so forth. In this case, I think the problem comes with is that the case is over and a party has won. So now going back to the allegations and speaking them as true when you have a finding of fact that it may not be true, right? The person they lost, that's where you now open up the defamation because they're like, well, hold on. If you're calling yourself a journalist, you're talking about fair reporting privilege, then these allegations, and you'll see that in most cases. Back in 2002, there was a lawsuit, these allegations were made but the defendant ultimately won the lawsuit. They say that last part to avoid the defamation piece. But I'm not sure if she said that last part. That's what I'm at.
Yeah, I agree with Nate as to that much. Once it's over, right, there's some sort of adjudication on it. And so you have to obviously take that court adjudication as a reality. And so if you're going to report on that, you have to be careful about how you go about it. So I definitely agree as to that much. And incidentally, I know this was a sort of an issue within more of your community, Charlotte, on the web, because I don't remember who it was. But there was someone in your community with these tax documents in bankruptcy or whatever, that they had a bankruptcy proceeding. And the suggestion or allegation was Katie Joy Paulson was taking these tax or bankruptcy documents and reporting on them, but subsequent to the documents that she was reporting at the time she was reporting them, there were subsequent things that showed that those things were unreliable. So she should have taken that into consideration. So that could be a potential problem. Do you know what I'm talking about?
Not right offhand.
Okay, great.
Not right offhand, I don't.
Okay, great. Yeah, so exactly the same thing. Like if you have a court document and there's other documents or especially other findings that show that information to be unreliable, you have to factor that into the analysis, because it's something that you should have. It would be like reckless disregard. You didn't read the next document down the list to see if anything had changed, right? That could very well be reckless disregard.
But it was LB.
Kind of like with Keemstar. Oh yeah, the LB situation. Yeah, I remember that.
Okay, yeah. Because I remember in the discussion we had on stream, you and I, Charlotte, when there's like 4 questions along these lines, and someone mentioned in chat that this was relating to a real thing, and I was like, oh, okay. So I was like, okay, I can use that information to say yes. If this is the case, then that might be a problem. Please note all my very qualifying language, because I'm good at this. Okay. Regardless of the light in which statements paint plants, and regardless of whether they agree, they're privileged against claims of defamation. I don't know. Maybe
that's a thought. That's
whole, very conclusory.
Number one is a whole throwaway piece. It's like
many of them. How about the other ones that aren't? See, many of them is not all of them. Now, is it? And to win your defamation case, you need to win against all of them. So, because if you have at least one standing, you might get some of them knocked out, so it's not like a total loss. You might win partially on your motion dismissed, but if you got other ones pending, we're going forward. So, many's not going to cut the mustard for winning this out of hand.
Yeah, that number one was bad. It wasn't bad. It was just laying out the standard, but it doesn't. I don't think it moves the needle any. So, matter of fact, I think it hurts more than it helps, because this journalistic stuff. Now she's kind of taking herself out of the whole, the commentary piece, and now made herself a journalist. So now these things, she's better. Hopefully they're factual, or she's going to be in trouble.
Yes. As to whether public figures may take action against journalists, or anyone for that matter, reporting on or publishing information about their investigations into public figures, the Constitution delimits a state's power to award damages for liability in actions brought by public officials against critics of their official conduct. Again, when they say public officials, they mean governmental officials, the government. As noted above, public figures are subject to. See, they're mixing the
public. They're mixing
These
them up,
public officials are not the same thing as public figures. She's mixing the concept.
Explain that.
This is a mistake.
Explain that so people understand, because a lot of people mix up public official versus public figure.
So first of all, one of the lesser holdings from New York Times versus Sullivan is because we all know about the actual mouse part, but one of the lesser known holdings is also that it's impossible to defame the government as a whole. It's just not a thing that can be done. It goes to freedom of speech, freedom to protest. You can literally make up all the lies you want about the government at large, and they can't do jack shit. You can just defame the government all day long. They can't get to you. Now, when it gets to individual officials within the government, that gets a little bit more tricky, and you can't go to quite that length. Now, if you're talking about things in their professional capacity, maybe, but you have to be careful here. It's not as absolute a rule. So when they're talking about public officials and these protections, they mean the government. They mean the government at large, or they mean a government actor doing things within their official capacity, and you perhaps defaming them about things within their official capacity, maybe, and quite probably that's protected. But if you start making personal things against them, even though they're a government official, right, that's not going to fly.
Correct.
Because now you're going outside their public role and into their private role, and so they're going to still have redress. But that's the kind of thing they're talking about with a public official. And then she starts talking about public figures, and like, no. Like, a public figure is anyone. It can be any private individual who has put themselves sufficiently, purposefully availed themselves, as we say, to put themselves into the public discourse. And so you can't read public official and public figure and be like, oh, these are the same thing. I'm like, no, that's no. You're crossing the streams Ghostbuster style. Please stop doing that.
I think an easy way, like Kim Kardashian would be a public figure.
Yeah,
right.
Because she's seeking public attention. And if you're seeking public attention, the rule is you take the good with the bad. But
Yes.
public figures aren't seeking; they're working on behalf of the public. But now, since they're government officials, in their capacity as public officials, they you can say they're doing a bad job, they're bad people, whatever, in that capacity. But in their personal capacity, that's when it turns different. So that's why it's important to understand. She's making the claim that they are public figures, not public officials.
Yeah.
Yeah.
So public figures are subject to vigorous attack that must show actual malice, which is not what it sounds like, and we've discussed that.
Yeah.
In this case, the United States Supreme Court articulated three classes of persons for purpose of analyzing defamation. Yes, a private individual, limited purpose, and full-blown purpose. A full-blown public person is kind of hard. That's a hard trigger to pull. A public person for all purposes. My sort of informal legal test is: have you appeared on the cover of the National Enquirer? If so, you're probably an all-purpose public figure. That's
Donald
my informal
Trump.
legal test.
Kim Kardashian, like
Yeah,
all the big names. When you say a name, everybody knows
big
what that's
names. Yeah. Hypothetically, it may be possible for someone to become a public figure through no purposeful action of his own, but the instances of truly involuntary public figures must be exceedingly rare. For the most part, those who obtain the status have assumed roles of exceptional prominence. Some occupy positions of such persuasive power and influence, they're deemed public officials for all purposes. More commonly, those classified as public figures have thrust themselves to the forefront of a particular public controversy in order to influence the resolution of issues involved. In either event, they invite the attention and comment. Go ahead.
I just want to make it very clear. So all this is making, which I think we can probably maybe skip. All this is making the distinction between the voluntary
skip the legal principles and try to get to actual facts that might help.
Well, because only all right. So
you want to take all the laws given?
I can sum this up right now.
Okay, go ahead.
There are different types, right? There's the involuntary public figure, like the Kyle Rittenhouse, right?
Mm-hmm.
He's in there, he's fighting, they shoot in, and now he's not because he wants to be. Involuntarily, he's a public figure. George Zimmerman will be another case, right?
Mm-hmm.
People who are thrust into the spotlight, who don't want it, but you'd be a public figure for that particular instance, right? In other stuff, you won't be, but for that, it's involuntary. Then you got the people like me, who going on YouTube, saying my stuff, making my videos.
I'm not conceding this point for the record.
Well, you're not conceding. I got no choice. I'm
a limited public
right?
person, so I'm not making conceded all he wants. Well, I am not making this concession.
I've been in the New York Times, New York Post. I've been on TV. I'm a public figure, and if somebody's going to sue me, they're going to sue me as a public figure. So for me, yes, I would tacitly concede it. As long as I'm not in court, then I might have a different story. But right now, I am conceding that yes, I am a public figure in this context. So then you have the voluntary, right? I'm seeking public attention. But then you also have those people who kind of don't, who are kind of in that I'm not seeking public attention, but then all of a sudden get into something that kind of gets them up, like Black Lives Matter. Like the person who was running Black Lives Matter, who wasn't really seeking public attention, they became the forefront of Black Lives Matter. So that kind of was like, well, they weren't kind of involuntary. They weren't really seeking public attention, but became so notoriety that now they are a public figure in that. So that's kind of what they're the involuntary, voluntary, and then those people who are kind of like have a little bit of both, but now they're public figures. Did that help? Did that get all three,
Yeah.
Kurt?
Yep, I'm good. So we can skip ahead, and then we can read the title of this, and I suppose just skip through this legal analysis as well. To recover against defendant, a public figure must meet the elevated burden of proof and show not only statements were false, but also defendant acted with actual malice, which they cannot show. Again, I'm not sure that they are public figures, and I don't know. I think that there was enough there to go forward at least, or maybe to get some, clarification. I don't know that they're actual figures. So are public employees public figures? Not necessarily.
No,
because
no,
the public
sorry.
employees covers a lot of ground. Like everyone who works for a governmental agency is suddenly a public figure. I mean, they
That's
can't possibly go that
the
far.
person who the
Can't
janitor at the
possibly go that
DMV.
far,
Yeah, the
right?
janitor at the DMV would be a public figure.
The political appointees, sure. The
Yeah,
bureaucrats, not so much.
yeah.
And even as to the political appointees, you could have a debate because it's like, does it necessarily apply to all the public appointees? Like, is the assistant secretary for, whatever necessarily a public person? It's like, you could at least you could have a discussion about it.
Well,
Before
but
concluding answers, yes.
generally, if you have to be voted in, or
I mean, that's
what's
true.
it
You do have to
called?
be Senate confirmed, so that kind
Yeah,
of
or
thrusts
Senate
you into the public
confirmed.
light, so there's that.
You're in, yeah.
Okay, fair enough. So, yeah, so it's probably a yes for all the public confirmed positions. Skip, 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 skip.
Here we go. Plaintiff
Paulson's
cannot be
own statements about reports she's received directly from former members of 7M cannot be actionable under New York Times of cases in Rose because they've even stronger defense they are true. The question is whether the statements themselves are true. Yes, it's true that you received them, but that's republication.
Yeah, so,
right?
so
And
you
so,
lose
like,
that. Yeah,
So that might go again to the standards of the mens rea with the negligence or the actual malice. But yes, it is true that you received the reports, but you then republished what those reports were. That's republication. And so if you get past the mens rea element, you're there.
yeah. So general, and so everybody understands. Generally, for newspaper, because people might say, well, what about a newspaper, right? So generally, what newspapers do is that it's first you get the sources, right? These people are saying this, but then you also have to do just a little investigation to make sure that they're not just saying nonsense. So if someone comes and says, this person is an alien, right, and I publish that could be defamatory because people will be like that, no reasonable person. So there's a standard of reasonableness, right? If someone tells me something and it's reasonable that, based on the whatever stuff I have, it's reasonable, then I can report it. But if it's not reasonable, then it's what they call republication, where you can't just say a defamatory statement and say this person said it.
Yeah.
I'm liable for it unless a reasonable person could find it to be true, and that's where it comes to the mens rea.
Yeah, unless again, because it's like maybe it's reasonable for me to rely on them, but they still have a problem for their underlying statement, right?
Correct.
So,
Yeah.
I mean, both those things could be true at the same time.
Claims like human trafficking and hitting people with
human trafficking is
cars.
pretty specific.
Yeah. Those things are going to be hard, but no newspaper is going to hear. Like, say, if I go into New York Times and say, "Hey, guess what? The 7M is human trafficking." Right, and then they're not going to believe me. They're going to be like, well, how do you know this? What's some of the evidence, right? But if they go and report that, then they're just as liable as I am for the defamation. That's the key. They have to go. That's why the reporters have to say, well, we got to investigate this a little bit to make sure this is just not BS. And for everybody who wants to know, that's how Tasha K. That's why Tasha K has to pay $4 million to what's her name, Cardi B, because she didn't investigate, but then eventually she found out, and that made it even worse. But that's essentially what happened.
Also, I get on the stand and say, yes, it was me. I did it.
That doesn't hurt your case.
That lies for the purpose of forwarding my business. It's like, well, okay, that kind of does the trick. So far in this motion to dismiss, I'm not being overwhelmed in terms of the analysis. It's like it's superficial, and it's kind of conclusory, and we're not really bringing forth information that would allow us to validate these conclusions. We're just simply saying, well, we have information, we have reports, but you're not making the reports public. So, I mean, you can try to keep your sources secret, but then you have a problem, right? You can't have it both ways. You can't keep your sources secret, assuming she has privilege, which is a whole other set of problems, but you can't keep your sources secret and then say, but those people that are reliable, they're reliable and I can believe them. Which people? I don't have to tell you. It's like, see, it doesn't really work.
No.
It doesn't work.
But what generally happens in cases like this is that you get an in-camera review of the sources.
That's usual. That's a very
so what an in-camera review is that the judge will say, okay, you don't have to show it to the sub, show it to me to make sure that you're just not, saying crap. And
Making
the judge will
up,
look at it, and say, okay, no, this person does have actual sources, information. So I'll go with the motion to dismiss.
Yeah. So far, I'm not particularly overwhelmed by this analysis. And they just took the public figure thing as a given, which, again, kind of irritates me. How are you getting there? I mean, I'm not saying it's not an impossible argument to make. Maybe you can make the argument. But the way they did it was so superficial and sloppy. They just say, "Oh, he's a pastor of an international church." I'm like, "Is he?" I mean, you can't. Do you want to like show that? Do you want to say, he has congregations here, 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 and they all tune in to a webcast live, or they all read his sermons, reread his sermons or whatever? You want to provide any information that would show that? That 7M is trying to make the talent public. Sure, of course, that's their job. That 7M themselves is trying to make themselves public. Again, not a given, right?
I'd never heard of them.
I've never heard of them.
I never heard of them.
I'm not saying it's impossible, but like, I don't think you can just say, oh, just because even assuming they do, which I don't know that they do, but even assuming that they have like a Facebook or a website or a Instagram, I mean, I don't think that quite gets you to the end of the point, because I don't think you can reach the conclusion that everyone who has a Facebook page or Twitter or TikTok or all the above is a public person. That just seems like an absurd conclusion.
Yeah.
So, I was like, she just takes it as a given. These are public people. I'm like, I don't know, man. And she just takes as a given. It's like, I have sources. They're super reliable. Trust me.
Now,
I'm
Kurt,
like, I can't. I can't.
they're public figures because Katie Joy said they're public figures. You didn't get the memo?
I did not get the memo. This is not.
Yeah, we didn't get it, Kurt.
This is not some of the best work I've seen in terms of a motion to dismiss ever in my life. Maybe it gets better, but so far it's not going great.
Let's keep. Well. Right now, essentially, we just got the. Let's see if she makes some good arguments here, because these arguments.
So far, it's not going great. And she keeps talking about overcoming constitutional protections for the press, and that just makes me, on a personal level, just want to get angry.
But for
you're not special.
For you wannabe lawyers out there, remember this though. This is a good teaching tool. Never take anything for granted.
Yeah. And
that's what happens here. Whoever's wrote this is taken for granted that 7M is a public figure by just allegedly by stating it. And we generally call that just writing a legal conclusion. Right, yep. She hasn't explained why. So you could write 7M as a public figure, but then tell us why. And and it's just not because it's an international. You got to say we got thousands of people watching. Just what Kurt laid out. And if you don't do that, then you're essentially saying the judge. Everybody knows public figure. You could do that with a Donald Trump. You can't do that with 7M.
Yeah. Okay. Okay. So tortious interference with contracts. So is this the end of the defamation case? Because if this is the end of the defamation pleadings, I'm sad.
Yeah,
I'm sad.
Denied. The motion to dismiss is denied.
That's kind of where I'm leaning too. I'm not buying this one.
Yeah, it's over. She's going to trial.
She just makes these global statements without any sort of evidence. It's like, oh, many of them are from government reports. Great. Which ones? Many of them. So many of them. Which ones? So many of them. This is not helpful to me as a court. I don't know what to do with this. I can't adjudicate this. What am I supposed to do with this?
And also, I want to make sure it's okay to super chat. If you guys have any questions, I don't mind answering them. But ask him in the super chat, and we will answer your questions. I see a lot of people throwing out questions.
Yes, help support the channel. So I'm like, I'm not sure about the answers. All right, let's see if the tortious interference gets any better, because they might be able to get somewhere on here.
It doesn't. But go ahead.
Well, we'll see. We'll see. I'll reserve judgment. To make a claim, they must show the existence of a contract, knowledge of the contract, intentional procurement of the breach, absence of justification, and damages. Fine. Okay. There's no allocation the Clippers contract was breached, nor is it likely breached, given common escape provisions in commercial entertainment contracts.
That doesn't work.
That's conclusory.
Yeah.
You don't have the contract. Bullshit. How would you know?
Yeah.
I mean, it might be true in the end, but it's not true enough to get past a motion to dismiss. Maybe on a motion for summary judgment, after some discovery, we have another person to join us.
But this is begging for discovery. This is begging for discovery. Yeah, we know what to find that out. Let's go to discovery.
we have another person to join the foray. So let us welcome LEB.
Oh, what's up?
Hey, LB.
Hey, sorry I'm late.
No problem.
It's fine.
We're having a good time.
Yeah, we're looking at this madness.
So far, it's not going great for Katie Joy Paulson here on the motion to dismiss.
Nope.
It's a little.
Imagine that.
A little conclusory. A little just doesn't provide you any information that would allow you to actually form these conclusions.
Okay.
So, yeah.
I'm interested in listening to everything you got to say.
Yeah, but we're hoping maybe it gets better than the tortious interference. We'll see. And then she says, without review, it was likely breached given common escape provisions. Yeah, you can't just speculate that into existence. No.
Yeah.
Without the contract review or allegation of breach, defendants cannot make a claim for showing of their cause of action. The claim fails. Yes, they can. Yes, they can. It's notice pleading.
She's in trouble, bro.
They have notice pleading. They can just. I mean, they have to give you something. They have to tell you which contracts there are. But apparently, you've been able to deduce which contracts there are. It's Clipper's contract, and so it's like, well, there's a breach. It's like, no, there's not. Well, it's like, okay, well, no, because now we have to get into the contract, maybe.
Yeah,
So
she's in trouble,
not
bro.
so much on the motion dismiss.
This is not going well. She's
Oh,
this is
and we
the
just
conclusion
reached
we're
the
in.
conclusion.
That's it.
Holy God!
That's it.
That's it for
That's
tortious
it.
interference.
That's it.
One paragraph. That's completely conclusory.
We're
I'm
going
sad.
to- looks like
the
we're going
lawyer
to
me is
trial.
sad inside.
We're going
I
to
am
trial.
sad.
Oh, this is
I
the
am so
conclusion of the
sad.
document. This is it.
I'm sad. The lawyer in me is very sad. So
This is the motion to dismiss. No, scroll down. Let's see if that's the last page.
no,
I-
it's definitely
It
the last
is. I
page.
promise.
There's
That's
yeah,
it?
that's it.
Yep.
That's,
She's
there's
going to
all
trial
there
on
is.
this.
There is no more.
She's going to trial.
You
That's
know?
a dismissal right there. There's nothing. There's nothing here.
Yeah.
Oh my God, Katie,
It's
get
not
ready
going-
for trial because 7M
not
is
going-
taking your ass to trial. This is a denial. Wow.
Yeah, we're definitely getting to discovery on this at this point because
These are all just legal conclusions.
these are all legal conclusions. There's nowhere near enough evidence to draw the conclusions that we need to draw.
Wow.
So, yeah, unfortunately, as I sort of suspected, I was like, well, this looks pretty good. Maybe she can get there if she has some really good stuff, and maybe she has really good stuff, but it hasn't been presented to this date up to this time. That, of course, doesn't preclude her from presenting it at some later point as part of the motion for summary judgment. So it's not like she's necessarily sunk, but I think we're going to discovery because.
Yeah, I think this motion to dismiss is going down in flames. Oh my God.
Yeah,
And she withdrew the motion to dismiss in the Todd Chrisley case.
she at least to
Why
my
was she-
mind had a pretty good argument for motion dismiss.
Why did she withdraw the argument to dismiss?
She wants to make counterclaims.
She wants to counterclaim. She wants to countersue.
But you can still countersue with the motion to dismiss out, right? You just file you serve the service counsel and you're
That's
good.
what I was thinking. She didn't.
Well,
have to
yes, I guess you
file it.
technically could do it that way. You could bring your own independent lawsuit. Yes, you could do that.
Yeah, and just file it. The counterclaim keeps that doesn't make any sense. So I don't know. Her legal team knows what they're doing. So
Do
Do
they?
they?
Well,
yeah, I'm assuming they do. I'm not licensed in Minnesota, but that doesn't make any sense. The Todd Chrisley case is just so everybody knows. Steve McRae's case, that's Fugazi. Todd Chrisley's case, that's Fugazi. This case though,
For Gacy, that's nice.
yeah, but this case with 7M, I'm sorry, Katie, you got a problem here because if this motion to dismiss, which I'm putting at like an 80%, 70-80% will get, and again, I said Toddy would be dismissed. I'm telling you, Chrisley should be dismissed. I'm telling you, McRae is not long for this world. This case seems like
It's got
I'm
some
on the other
legs.
side. Yeah, it's got some
So
real
yeah,
legs.
everyone who's been secretly hoping that Katie Joy may go down. This
Congratulations.
is the best. This is the best I've seen
Yeah,
so far.
This is what we're
I
waiting
just
So-
clap.
Again, that isn't to say that she can't win on a
Right.
motion of summary judgment after discovery. Isn't even to say that some subsequent motion dismiss with more could somehow work. But based on what we have, no, it's in my humble opinion, definitely proceeding to the next step. And also joining us is Stephanie. Hello, Stephanie.
Stephanie.
Hey,
Hello,
Stephanie.
everybody.
Hey, Stephanie.
Stephanie told me she's gonna take me to shooting when I get down into Houston. Is that true, Stephanie? Are we going shooting or what?
Game on, Nate.
Yeah, I say all that now. But I'm scared because you know how Black Lives Matter going out in Texas and I grab a gun. Next thing I know, I got to worry about the police and all that stuff. So, but I'm thug like that.
I'll protect you, Nate. Don't worry.
I got my bulletproof vest just in case because I know how you do. So I'm gonna come down there with the bulletproof and everything just in case because Stephanie has like a whole arsenal in the house. So.
Where's your plate carrier? You know that 3A or 2A is not stopping anything I have.
Well, hold on. Do you have a 9mm? This helps me with the 9mm. And I
Nope.
saw you clean a 9mm on your channel.
I did
So-
not. I have never cleaned a 9mm on
I
my
thought it was
channel.
a 9mm. that you have?
40
No?
caliber, 45, 44
Oh,
Magnum, and 50 caliber.
That's so true. It was the wrong. You're right. Wow.
Stephanie's
All right, so
scary.
I'm not going to be meeting with Stephanie, guys. Stephanie's just at another level now.
Yeah. We did have some super chats along the way, so I'd like to read those since we've sort of got through the discussion and see what we got so far.
Okay.
So $5 from Hollister, maybe a dumb question. If a person has a mental illness with a symptom that causes them to lie all the time, would that be protected from being sued?
No. There's
No.
no insanity defense for defamation. I was
there's really no insanity defense for defamation.
But you know what though? This is the problem. I think Katie, I think, is trying to have it both ways. And I
Yep.
know she's probably going to rant on me when it comes to IG. Katie, please rant on me. Say my name because I need more subs. Right? I'm almost catching you at 200,000. So I need them. So rant at me. Tell them Nate is a bad guy. Nate's a horrible lawyer. Even though, and I want to be also clear so everybody understands. Me and Katie were cool. Katie's, she would be and her were cool, and we were all right. But Katie, I'm going over your case. So don't kill me too much. But I think the problem that she always has, and she did it with Elle, she's done it with Charlotte, is that there's but so much you can say without defaming people, and most people don't have the money to go and sue somebody to defame them. But Katie she started small. She started with like the Steve McRae, which I think she defamed them. I know Steve's gonna love this. He's gonna be like, Nate, I hate Nate, but I love to defame. All right, Steve, she defamed you. Yes, I agree with that. Elle, God, my God, she defames you like every day. I mean, she probably defamed you right now.
Probably. Probably on Twitter defaming me.
She will be, yeah, I'm sure.
And Charlotte, oh my God, Charlotte, I've never seen her say anything nice about you. So,
She never has.
but the fact of the matter is that she doesn't have you guys don't have the money and none of the time nor the effort to even want to sue her. 7M does. 7M may not be a public figure. And the win here for 7M and the lawsuit for Katie is not, see, people need to understand. The reason why 7M is suing her, not to win any money, Katie doesn't have the type of money they want. They're suing her to bankrupt her. That's where they're suing her.
Maybe.
And if you get past the discovery phase, discovery is extremely expensive and a trial is extremely expensive. So if you get past the motion to dismiss, which is cheap, then you're talking about maybe $50,000 to $100,000 to get out of this mess, which is crazy. And think about the Toddy suit. She spent, and I'm going to say it, about maybe $20,000 to $50,000 on just the Toddy motion to dismiss to get rid of that case. And that
I thought
didn't
it was
trial.
more because of the so many precipes.
That's
Many precipes.
So many.
I don't even know the last time before that I'd heard the word precipice. When the first time she said it, I was like, what the hell is a precipice? And then I heard it so many times. It's burned into my mind now.
But the one thing though, and this whole thing, and I hate to give people who hate me ideas, but if Steve McRae, Todd Chrisley, and 7M were smart, they would combine their litigation strategy. In other words, let's all hit her together. Instead of letting, like Steve McRae's case, he's still got problems getting money to file it. But if Todd was smart, Todd would say, let's give Steve some money so he can continue his case. She's got to burn cash there. She's got to burn cash with me. She's got to burn cash with 7M. But instead of doing that, they seem to not be understanding this is what you need to do if you really want to get her.
Yeah. Well, 7M might be able to get her because,
Yeah, I know she's going to be hating on me soon. So how do you think that she's on IG now saying how bad a person I am, or she's going to be
Probably.
on IG
She
in
will
like
be
half an
tonight.
hour?
Let her get up.
I imagine some harsh words might be put in my direction.
Oh,
I
yeah.
don't know
The
for
person
sure.
she likes is
And,
uncivil.
Wait till she drinks some Jesus juice tonight.
That's what I'm saying.
And
Yep.
for whatever it's worth, she's entitled to her opinion. So if she,
Yep,
wants
sure.
to, say that I'm an idiot or whatever, then it's like, she's entitled to her opinion. She obviously can't make up facts. That's a problem as we're just learning.
But you know what?
it's
The
like,
part
okay.
the part I hate about this is that when we were the only ones, me and you, Uncivil, saying that she was going to win the Toddy lawsuit, right?
Yeah.
we were the only two. Like,
That was very uncomfortable. It was very uncomfortable in my chat for a lot of the time covering that Toddy suit. It was very uncomfortable because so much of the chat would be like, "You must be Katie's boyfriend." And I'm like, "Look, I'm just trying to assess the law. This is what I think it is."
Yeah, we're the only two. We're the only two that said she's probably going to win that suit, and we're the only couple of people are saying that she was going to win the Steve suit. We're but and the Chrisley suit, not a lot. Well, even Emily's kind of said that the suit looks bad. I think everybody's saying that suit looks bad, but with this one, girl, you got a problem. You got a major problem. I don't know how to but this motion to dismiss. If this is the best you got,
yeah,
I'm sorry, girl.
It's not great.
Nah. So what do you think? What do you guys think this goes from here? What do you? Well, L, because you've dealt with this for the longest time. I two questions. The first is this kind of some vindication for the stuff that you've been going through with this woman? Because obviously she's been defaming you for a long time. How do you feel about this? And how do you feel that this seems like she may eventually now get caught in this whole mess?
Yeah, when Tati sued her, like, I was like, great, this is justice for the people that she's hurt. Me, so many people. Even up until that point, there was a lot of people that other people had no clue that she had hurt in so many ways. So when Tati sued her, I had a lot of hope, So when I heard, some people saying that it was not going to go anywhere, that Tati wasn't going to win, I was kind of let down by it, because I was like, this is what some people need, because I have six children. I can't finance a lawsuit against her. She makes more money than I do. So yeah, if 7M or whoever can bankrupt her, shut her up, something, yeah, it will be sweet vindication for me.
Yeah. I hear you, because I've seen it. I've seen it too for you too, Charlotte. What about now? This is again. I feel bad for saying this because I know people are going to be jumping all over me. What about helping Steve get his lawsuit? Because Steve obviously needs about, I think, $5,000-6,000 to get his lawsuit off the ground. If his lawsuit was to get on, it's just another hurdle for her to jump on. Are people thinking about helping Steve support his? Because I know right now people are kind of figuring out what happened to the money before, like, because a lot of the money disappeared all of a sudden. But now, are people still hyped? Because I know he got like $5,000 from the community for that. And he needed $20,000. So are people thinking about maybe helping him with his to get justice, or is people just saying, let his die out and we're going to hope with 7M?
I think we're hoping for 7M.
I'm not particularly hoping for either side, as always. Right? I'm just hoping the truth will out. The truth will out, and justice will be done, and the right result will eventually emerge. I don't really know any of these people. I don't know who 7M is as a company / church / cult. Maybe they're bad. Maybe I don't know, and I'm definitely not making factual allegations because I have no clue. But maybe some or all of what she's saying about 7M is true. I don't know. Maybe they do mistreat talent. I don't know. So, I can only know what I'm reading and assessing. What I do know at the moment is that this motion to dismiss is not working.
Yeah.
So,
Stephanie in.
Go ahead. Is that Steph?
Nate, you're safe for right now, because as of right now, she's banned from Instagram Live still.
Why is she banned from Instagram Live?
I'm not exactly sure, but she's been blocked out of it for a few days now.
Oh, wow.
But we got a couple questions that were on Charlotte's channel and from the audience. So Nate and Uncivil, we have questions for you that you have to explain to all the peoples.
Cool.
You guys ready?
Let us know. Yeah, we're ready.
So people want to know, since she is WACB as an LLC, does it affect the case? Does it help you if you're sued for defamation if you're an LLC?
I think they're suing the company and her individually. Yeah. So sometimes you do an LLC to kind of protect your personal assets. So they'll sue the company instead of. But I think in the 7M suit, and so was Tati, they sued both, right? Her as an individual and the company. So, and I'm assuming she has insurance too. So sometimes it all depends on the type of insurance that she has. I'll give a quick. So, if you have your own company. It all depends on the type of company you have. But if you have, let's say, a not-for-profit, there's what's called D&O insurance, which is directors and officers. So the people who run the corporation are insured where if they make something happen, then, for negligence, generally negligence, you can insure yourself against negligence. But intentional torts or intentional actions, you can't really insure against. So slip and fall accident, right? Somebody spills something, somebody slips and falls. It's an accident. You were negligent not cleaning it up. You can get insured for something like that. But let's say if I throw water on the floor to make you fall on purpose, no insurance company is going to insure you for something like that. So generally, intentional torts like defamation is what's known as intentional tort. You intended to do that. That is something that generally you can't insure against. But negligence you can. So right now, it all depends if her insurance, maybe, but she could have some type of insurance where, again, I don't know the type of insurance she has. She could have a type of insurance that covers intentional torts, but I don't, most do not for that reason, right? Because if you have a, you can easily bilk them, right? You could just do something intentionally and pay out to your family or a friend or something like that. So that's generally why intentional torts aren't covered.
Yeah.
Okay,
And it's also a problem because at least the problem is she does not do a good job in terms of making sure that her content is understood as being part of the business enterprise, right?
Yes, correct.
So she doesn't there's no screen at the end of her content which says, copyright Without a Crystal Ball LLC, a production of what. She doesn't say it orally. She doesn't do anything to really make her clear that her content is done by the corporation. So I think a court is not going to have too much trouble saying that there's a problem there. Yeah, it's piercing the veil. I'm not sure they have to, strictly speaking. No. And I think she's in trouble because of that.
But all right. So 2 questions. Number one, for you guys who know more about this. Number one, I'm assuming everything she does on YouTube is part of the Without a Crystal Ball LLC. Were all these statements made under the YouTube umbrella? Because then let's say if I go to Twitter and say something that is not a part of the LLC, then that's me personally. So can they make or have all those statements that they have been pointing to? Is it all based from stuff that she said on YouTube, or is it stuff that she said all over the place?
All platforms.
On Instagram, yeah, but basically Instagram.
Okay, all right. So she.
Nate went away. While he's gone, let me do another super
chat.
chat.
Say, do your super chat.
Because the company's not saying it.
Yes, question from Will Kleem. Will her mixing 7M and the church in her reporting be an issue? Yes, quite possibly.
Mm-hmm, yeah.
Because she might be able to. This is a problem, right? Because to the extent that these things about the church are true, well, yeah, to the extent things about the church are true, it can't necessarily be read on the company and vice versa. Now, you can get past that by, with some, a little bit of, writing, but not so much here on the motion to dismiss. She has not done, other than saying he's the CEO and he's pastor of this international church. She's not shown any connection between the two. I mean, a person who's one job can also have a different job. Then those jobs can be completely independent. There's nothing stopping a pastor or a rabbi from also having, a profession that's not related to that. So, just because it's like, oh, he's pastor of the church and he's CEO, therefore they must be the same. I'm like, no, not really. No.
But let's also keep it 100. She has hurt her case by calling herself a journalist, and I don't think we can understate that as much. Rachel Maddow and Tucker Carlson, they literally called people what Russian agents and what was the other? What did Tucker say? Tucker said that she was extortionist. He called the woman an extortionist, and the fact that they were opinion commentary channels saved them, right? Because they even admitted we defamed the person, but because we're no reasonable person will believe. This whole thing about I'm really a journalist and journalistic privilege, that's not really going to fly as well, because now you've taken that argument of that we're a commentary channel off the table, and you've made it now easier for them to win this defamation suit. So I think that was a huge mistake to even put that in there. She should have just stuck with the straight defamation. I think she would have had a better chance.
I feel like we need to change Kurt's merch and stuff, saying, the home is special. The home is special, but being a journalist isn't.
Kind of, sort of.
Oh, yeah.
$5 from American Legend. Years of working on ancient hardware, but now new built parts arrive soon. It's a big step forward on pay for itself. Thank God in heaven. Yeah, I as somewhat infamously built my new computer on stream. It was an interesting stream. And so, yeah, I hadn't done my stuff for quite a few years. And AD gave $2 say, are public employees public figures? Again, not necessarily. You can't possibly, to my mind, go to the conclusion that they are all public figures.
That means all public school teachers are public figures. That means the janitors in the public schools are public. Yeah,
that can't possibly be true.
Yeah.
Was there another question from Stephanie?
Oh, there's lots of questions for you guys. Everybody wants to know if you do have to disclose your business insurance and coverage in any lawsuit, because everybody has gone back and gone through every one of her previous lawsuits, and she has never disclosed her insurance to the other side.
Most of the time, you wouldn't see it through your lawsuit, because I've been involved in a couple where the other side, where it was an insurance carrier, but you wouldn't know that based on the pleadings. It doesn't say like my insurance carrier's lawsuit. What happens, the general way it works is that, well, when I was a part of a not-for-profit, and we had got sued, and the insurance company, what they do is we'll have our own in-house counsel, and then the insurance company will say, like, you know what, if we're going to do the case, so then they'll pay for like a law firm, and then that law firm will come in and they'll just take over the case, and and treat it just like we'll be the clients, but the insurance company pays for it.
Okay. People want to know if her underrepresenting the amount of subs she has is an issue.
I mean, not really.
Not
I don't
really,
know why she wrote 180,000, because it's more like 230,000 or something like that. So I don't know why she did that, and I don't really think it makes much of a difference one way or another. But it's like, okay.
Does that extra 50,000 make you a public figure? I don't think so.
I don't know that really does anything one way or another. So I'm not sure why she underrepresented it. So seems like a strange thing to
it would actually
underrepresent.
I think it would be better if she overrepresented it, because then it makes her.
Imagine.
Yeah, because but underrepresented, I don't know why.
Do the rest of your super chats.
Oh, I got 11 of them left in the queue.
Well, let's go through those first.
All right. $5 from AXBX Ray. Will the court add weight to the case because of an apparent pattern of defaming others? No. This is all prior bad acts. No,
Yeah.
you can't bring in other stuff to prove this thing, right? That is not how one of those things work. You can't show once a thief, always a thief. That's not good. So a court will absolutely not take notice, even if she had been adjudicated like liable in those other cases, incidentally, even if they come out negatively against her. A court is absolutely not going to take notice of it, because like every case has to be considered unto itself, and you can't use propensity evidence. That's a total non-starter.
Yeah, you can.
Okay. I think, Kurt, you and I had discussed this, and let me just clarify, because I think this is where we have a disconnect with a lot of the viewers with the propensity evidence. Everybody is looking at this like they would 404B evidence in a criminal case, when that isn't the same thing. So you can't use her evidence of prior bad acts to prove that she's defaming people now. The only time this is going to come in is if they're saying this is a pattern. You're trying, after she's been found guilty of defamation, make her sanction bigger. It's a pattern. You can't say because she did it in the past, she's doing it again. So yes, they can bring it in to show that she's done this, but not for the purpose of proving she's doing it now.
Right.
And I think that's where people are getting confused.
It might be able to be brought in for damages, but not liability.
Yes.
So
well,
that's
And I think that's the confusion.
And that's also true in a criminal case, incidentally. Like if they will not let into evidence in a criminal case, you've been a thief or you've committed 10 DUIs. They're not going to let that into trial. Once you've been convicted, now it's like, okay, we're not using it to prove liability. We're using it for this other purpose of damages. And it's like, oh, you've done this 10 other times before, so it hasn't worked so much. Maybe we need to up the penalty.
Yeah.
So that's the difference there.
But there is a little context that I just want to. I think I need to add just for the law people who want to practice law. You can bring it in for a different purpose. So for instance, I can't bring in evidence that you've done this before to show that you've done it now. You're acting in conformity with prior bad acts, but I can bring it in for other purposes, to show motive, for instance, to show opportunity. There's a famous case of the pizza. It's the pizza, not the pizza. It's the pizza sauce bandit. So there was a guy who was breaking into safes, and he would use pizza sauce. So what he would do is take the I keep saying pizza, but it was pizza sauce, and he would push it into the locks and then freeze the pizza sauce. It would expand, and then he would break open the safes. He had done this like 100 times. So generally that would not be allowed in because it's propensity, right? Hey, this guy's broke into 100 safes with this pizza sauce, right? We know it's him. So generally you couldn't bring that in because you would show, well, he broke into this safe, but he broke into 100 others. But they were able to bring it in because it showed a uniqueness. How many people are breaking into safes with pizza sauce? So because of the uniqueness of the crime, you're able to bring it in to show the motive and opportunity in that sense.
Unique
to show
signature.
Exactly.
Yeah.
So there are ways you can bring it in, but in her case, her lawyers, well, 7M's lawyers would have to find a way to bring it in outside of the propensity issue. I know that was long-winded. I'm sorry, guys, but I used to be a professor at a law school, so.
No, that's good,
you're all
man.
good.
You're fun. Joe Being Joe became a new YouTube member. Always
Joe?
happy to have new members. Make sure to hit that join button. It is appreciated. Was it proper for the U.S. attorney to tell without a crystal ball Lindsay Chrisley was a witness in the federal trial, considering Lindsay Chrisley denies that?
Possibly.
I don't know.
So I think there's a little bit of context. So a little bit of context with it is she has been saying to everybody and releasing a proposed witness list that she obtained from the court documents in the federal case. And she's saying she has been talking to, she's saying that she's been talking to the FBI agent in charge of the criminal case and getting all of this information from him. So that's what everybody's trying to figure out, because they're saying she took this unpublished possible witness list, not the actual witness list that was going to trial, and blew it up online. And was that inappropriate, or can an FBI agent in fact give information to an uninterested party? And that's what that's coming
Definitely
from.
not supposed to.
Well, so everybody understands the Justice Department's policy is they never they don't say they they don't confirm nor deny anything. So it's just like, whatever, right? We don't know either way. Witness lists that are public, I think she can publish if you can publicly get the witness list. The second piece is that I don't know what harm it would do to Lindsay Chrisley if she was or was not on the witness. It's not defamatory to say somebody's on a witness list, right? James Franco's on the witness list for Johnny Depp. So I don't know if that's. I don't know if there's any issue with this.
It's a strange thing to think is defamatory. It's like, I mean, you would reasonably anticipate that she might be on the witness list. That's logical. So it's like, whether she is or is not, it's like, I don't know what the damage is from that.
Yeah, would be.
Nate and Kurt, no, she's not. They're not saying that there's defamatory issues from her publishing the witness list. The argument people are making, and that she was making, is that she shouldn't have to give discovery. She shouldn't have to give information. She shouldn't have to turn these things over about Lindsay, because he's going to take information about Lindsay Chrisley from the civil suit and use it against Lindsay in the criminal suit. So that's what they're trying to tie it in with.
All right. So
Okay.
They're saying, I'm not giving it to you. You're going to use it against her in a criminal court, and it's tampering with a witness.
But two things though. If it's material to the criminal case, then you'll see subpoenas getting it anyway, right?
Yeah.
We'll out the criminal case will subpoena it if it's necessary. But the second piece of it is that Todd Chrisley. I'm assuming Todd Chrisley is suing without a crystal ball to two things: to shut her up. That's what this is about. And I think his lawsuit is weak, but I think it's effective in forcing her to spend money to shut up, because essentially if it's shut up and we'll leave you alone, and I don't think she's going to do that. I think, and that's why she's saying I'm a journalist, right? Because he wants to shut me up. So
$4.99 from Sarah Loves Donuts. Donuts are tasty.
Yeah.
What about the amount of reporting? She made accusations nonstop all day on several platforms. Yeah, it's kind of neither here nor there. Whether she makes one statement or a million statements, the question, of course, as always, is whether or not any of those statements are a problem or not. And her prolificness is not relevant. If she's only reporting, if she's reporting true things, she can report true things to her heart's content. So I don't really think this really goes anywhere, but I appreciate the super chat. AXBX-Ray says, KJ posted she would continue to report on 7M. Will any additional reporting open her up for more punitive damages? And love me some Charlotte.
Oh, thank you.
The answer is yes, and also it could be brought in the suit proper in an amended complaint.
Yeah.
So if she's continued to making new accusations, then those accusations may very well be able to be brought into this complaint. So yes, that could be a problem for her going forward.
Katie, do you hear that?
I'm talking directly to her.
Could be a problem for her. It's like qualifying everything. Like, this could be a problem. This might be an issue. It's like, because you don't want to state anything definitively, because it's like, try to protect yourself a little bit.
Yeah.
Tan, $10 from Wickard Craft. Thank you very much for the super chat. It's appreciated. Ginger Roost says, "Will KJ have to show up in court?" Yeah. For this one, it's okay. That's depends what you mean. Show up in court. If there is a trial someday, then yes, she'll have to obviously show up for that. Whether if there's a hearing or sort of any other process, not necessarily, and you wouldn't necessarily expect her to, for that matter. Hearings are usually done by the attorneys. The client's not usually there.
Yeah.
They can be, but it's a little atypical. So you wouldn't really expect her to be there in any proceeding before the trial occurs. So I wouldn't bank on it. Do you have anything else, Stephanie? Another question in the queue?
Did you get all your super
Not
chats?
yet.
Why don't we do those, because there's people waiting for you to cover
Sure.
them, and then we'll go with the other ones.
Are you familiar with Curtis Publishing versus Butts? I am not. Are you familiar with this case, Nate?
Nah, I have to look it up. I've heard of it. I feel like I've heard it.
Curtis Publishing sounds familiar.
Yeah, it does sound very familiar. I don't remember it though. There's so many.
$20 from Merrill Lynn. This stream is like chicken noodle soup for my soul. Awesome. Also, KJ says insurance will cover all of it. Yeah, I don't know the degree to which that is true or is not. Katie Joy said the same thing to me. She thinks that her insurance protects her. I kind of hope for her sake it does, because this could get expensive, and she's already gone through quite a lot of expense for things. So, but she seems to do well for herself. So, I don't know. We'll see. $10 from Isabel Lamy. I love you guys together. Awesome. Well, thank you very much.
Thanks.
$20 from Nell Smith. Hello, Renell. Hi, girls. Hi, guys. Kurt and Uncivil. What's the deal with her understanding her number of subscribers? Yeah, I don't really understand that either. I don't know what her motivation would be.
What you said? You got 5 subscribers?
No, she said like 180,000. It's more like 230,000.
Oh, see.
So it's like I don't quite know why you would say that, but okay.
I believe she just copied and pasted that off of the Todd Chrisley lawsuit.
Probably.
Because the same paragraph was in his lawsuit.
That makes sense.
$5 from Flying Monk Mom, Laura. If you're reading the lawsuit from a lawsuit as fact, and apart from the ruling in the lawsuit says the person was not credible in court, are you screwed? Not necessarily, right? It's
as long as you make it very clear.
Yeah, you kind of have to make everything clear. Like you just have to like bring that information to light. It's like, well, here's what the court found, as part of their analysis. Because, you can always disagree with a juror or a court, right? Just because a juror or a court finds them not to be credible doesn't mean that you have to agree with that. If you have, you can have an opinion, but you should probably represent that, court came to those findings to prevent people from understanding what you're saying as part of the factual record.
And this is what goes to that legal strategy about not saying that you're a journalist. Because if you're saying that I'm a commentary channel and these are opinion pieces, then it wouldn't matter, right? Hey, I covered this lawsuit and I was giving my opinion. These weren't factual recitations. But by saying you're a journalist, then you kind of put yourself into that box where if you do say things that are not factual and you're reporting on something, it kind of opens you up to that liability.
It's potentially a problem. So I would gear up if I were her. We got a couple other ones, super chats coming in. Okay, strike that one, bring this one. American Legend 855. Defamation is defamation, and is never okay in my mind. I dislike the public figure thing, but I understand it's the law. There have been some questions about New York Times versus Sullivan, I believe most prominently from Justice Thomas. Who's questioned the thing. And that's for me, I think that the biggest problem in my mind with New York Times versus Sullivan is it wasn't written at a time with the kind of communications we have now.
No.
It was written before the internet. There was a time before that, right? And so now that like everyone has social media and everyone can have a YouTube account, it's like it can't possibly be the case that like everyone with a YouTube account is a public figure. It can't possibly be the case that everyone with a social media account is a public figure. This can't possibly be true. Yeah. But it's probably true that some of them are. And so the question is like, well, how do you decide the difference? And this is where I'm like, that's a good question. I don't know. Because New York Times versus Sullivan wasn't really meant to deal with this. So I think New York Times versus Sullivan needs a needs some reconsideration for that reason. It's like, how does this work in the social media age with public figure? Because this was where Nate was saying, like, Nate said he was a public figure. I'm like, I'm not willing to concede that ground because honestly, I don't know. I don't know the answer, and because it's like it really wasn't meant to deal with this reality.
Well, I agree 1,000%. I think that would probably be the only issue is to define public figure a little bit more, because again, I think there are clear markers. For instance, someone with 1 million subscribers, a PewDiePie, for instance, or a Philip DeFranco. I'm calling them public figures, right? I don't think there's going to be a fight, but I think where the fight does come with someone like me. 200,000, kind of not. Where's the bar? And I don't believe the Supreme Court's going to be like, your sub count, if you got over 50,000 subs, you're a public figure.
Yeah, probably like not going to do that.
But if the test is what it is now, essentially, if the person is seeking public acknowledgement, and you got to take the good with the bad, then I think you can make an argument that you're a limited public figure. On your, like I say, if you got a cooking YouTube channel show, you may be a limited public figure in that sense, but maybe not. I don't know. You're right. It has to be kind of.
I feel like that
out.
Can't be true. I agree with Nate that that's what the case law says up to this point, but I feel like that can't be true. It can't be true.
It's just not
that, someone who's posting a cooking video on Facebook or even on a YouTube, if they've got 5 subscribers, it can't. How can it possibly be true that this person is a public figure at this point, right? And so, like, well, how do I draw the line between 5 subscribers and 100 million? Good question. I don't know.
Who knows? Yeah.
This is where we need some more help.
Kate? Well, hey, somebody should sue Katie with 5 subscribers. We'll see.
Yeah. $2 from Azira Sin. All around good chemistry in this live stream. Well, thank you. I think
cool.
so. It's been a good time. Tammy Little becomes a new member. Always appreciate people becoming members. Hit that join button. Uncivil not banging his head against the wall. Law. No, because she didn't say anything like that was stupid. It's just that her arguments were, to my mind, conclusory and not well supported. I found it to be unpersuasive. So we're not quite in banging head on the wall territory, but it's
so wild because how as good as the Chrisley. It's like she goes all over the place. Like the Toddy response was great. Was horrible. I'm talking about great. Was horrible. The Chrisley's response was great. The Steve response was great. This response is back horrible again. It's like the lawyer is just like Jekyll and Hyde. Like today I'll do a good one. Tomorrow not so much. All right, now we're back to another good one. So
I like this question. Is an influencer a public figure? My question is, what is an influencer? Right? And so it's like, what is that? Is it someone who calls himself an influencer? Because again, it gets in the same problem with a journalist. Like, is this a term that has some meaning? What is an influencer? How do you determine that? I don't know. So it's like I don't know what that means.
Yeah, who knows?
In a legal sense, right? I have an idea what it means in sort of a colloquial sense. I have an idea what it means in common speech. But in a legal sense, I have no clue what that means. So I don't know there's any case that has said this is what an influencer is. I'm like, I don't know about that one. And if it is, it certainly hasn't reached any kind of consensus yet.
Yeah.
$2 from VSync. My favorite precedent on this is Arkel versus Pestram. I'm not familiar with that case either. Mm-mm. And our last super chat for the moment, Ronnie G, $5. Thanks you panel. Props to Stephanie for making the collab come together. Yes, major props to Stephanie. For helping to bring this together and organize this. It was super appreciated, and that she does a lot of work behind the scenes, helping me find stories, and it is always appreciated.
I love this. Cheers, LawTube. Remember, Stephanie is your main witness. That's who you want to go to if something happens to me in Texas.
I think you would mean suspect, Nate, not witness. I wouldn't be the main witness in this.
No, you are going to be the witness because it's probably going to be Kurt that kills me. That's why. So.
Be nice. Don't fight with me, Nate. You don't want to. We have Wicked Crafter who would like to know if they go out onto the street and randomly start interviewing people to see how many people know who KJ is, if they can determine if she's a public figure.
Not under the current test.
Not
really. No, it's
because
it's a purposeful availment test.
Yeah,
which is a question of law, not a question of fact. So ask a judge, I guess, not ask the person on the street.
I think to be honest with you, KJ and myself, it's going to be hard to say we're not public figures. It just is. It's just going to be difficult. But I understand why Kurt doesn't, because Kurt says a lot of crazy stuff on the channel, so he's trying to be like stay away from it. But I think the problem, KJ is, if KJ wants to stay away from this defamation stuff, she needs to put on her channel immediately. This is pure commentary. These are not facts. This is all opinion, and I think that goes
would
really
help.
deep in the
That would help.
because
It's
now
not a get out of jail free card, but it helps.
This motion to dismiss would be written differently, where hey, no reasonable person will believe what I'm saying are facts because I'm a commentary channel, and you cite Rachel Maddow and Tucker Carlson, and I think now you say okay, she has a really live shot to get in this kicked on this motion to dismiss, and I'm surprised. Yeah, so
Yeah.
People want to know if her saying that Todd Chrisley is gay could be defamatory.
no, being gay is not a defamatory statement. Calling someone gay is not defamatory.
Yeah, I don't think it is.
Not anymore.
It probably isn't now. Yeah.
Yeah, back in the day, yes. In today's, no.
Hold on, I got to go through the whole list of them over here.
I have a question. Katie Joy said she's going to countersue Todd Chrisley, right?
Mm-hmm.
So she withdrew the motion to dismiss. Now, on his podcast last week, he was speaking about Katie Joy, but he was only calling her that YouTuber, the YouTuber.
YouTuber.
Yeah, the YouTuber. So can she use anything that he says against him while he's calling her that YouTuber?
When he don't name her.
Probably. It's defamation by implication. It's the same thing with Johnny Depp.
Gotcha.
Yes, and because the 5 elements of defamation are false statement, published to a third party, about or concerning the plaintiff. So if it's about the plaintiff, to name them, but if it's concerning the plaintiff, and that would be concerning the plaintiff, that YouTuber. So yeah.
Gotcha. Thank you.
Yeah.
Okay, can either Nate or Uncivil please explain what goes on in a settlement? I'm a crim major. KJ keeps saying during mediation she would have won, but they settled.
Oh, yeah. Yeah,
You
she
don't
does
win
say
it.
that.
You don't win in mediation. Mediation is literally, to win a mediation, you settle.
Yeah.
It's like I won mediation, but there's no winning. That's the reason. That's a mediation.
Yeah, a mediator isn't an arbiter. They can't force the parties to do anything. Their job is to try to help the parties reach a settlement
Yeah.
in mediation, but you can't really win a mediation. That's not really a thing.
Yeah.
$2
I won
for
by giving up
another
my
truth.
source.
What a time.
Right.
Crazy.
That's what she did. She just
Yeah, she gave up her source.
which to
Yeah.
me is not a win if you're a journalist.
No.
You're talking about for the Toddy Westbrook stuff.
Yes.
Yeah.
Yeah. But that's all Toddy was suing her for. She could have the crazy thing about the Toddy, and I tell Uncivil this all the time. The crazy thing about the Toddy Westbrook lawsuit is that we saw the plan from Toddy to bill her up, to get her to spend as much money as possible in the wrong court, in the wrong state, on the wrong issues. And that's all, and she fell right into that stupid trap and spent all that money, and then guess what? Well, you're in the wrong court, and then guess what? Toddy's like, all right, so let's go to the right court and do it again.
That was intentional?
Of course that was intentional.
Okay.
I'm not, well, I don't know if it was intentional. I'm
But
just
your
saying, it's my opinion that as a litigation strategy, let's see if we can get it in Washington, burn her out there, and then threaten her with suing her in her own home state where she can't get out the jurisdiction.
Right.
And then and then we got to spend. So in other words, you get her to spend the money twice. And all those, like Uncivil said earlier, all those precipices, all those hours of conversations, that lawyer was billing like, yeah, baby, he's like in a strip club with $1,000 in singles, just throwing them out there. Like, give it to me, Katie. And then now that she has to wake up and like, oh my God, I might have to do this again. Well, Clark Swanson. Yeah, right.
Period.
Yeah.
So clatter.
So
Right.
yeah, and let's just end this. If I was Katie, and this is something I would have done if I had the money to do it, I would have had them file in Minnesota, filed the motion to dismiss, which is really which wouldn't have cost that much, and then had them buy the information. Now she could have done that, right? They'd have had to pay me for that information, because I still think her motion to dismiss would have survived in Minnesota. But maybe she just said, you know what, I'm not even going to deal with it. Clark Swanson's not worth it to me. I'll give it up and call it a day.
So her saying she won that suit, she says that. She's like, oh, I won that lawsuit. I won that lawsuit. Technically, she didn't because she had to give up her source. I mean, it was
Yeah, she didn't win.
dismissed.
She
Say that
didn't.
again?
No, she didn't win. She didn't win. You're right. She did not win.
Okay.
Well, she got it dismissed in Washington, but she didn't. The Minnesota thing, she didn't
Yeah,
win.
they could have
settled.
refiled.
Yeah, they settled.
Okay.
Okay, we have a question. Somebody said they read that in Minnesota, the SHIELD Act does not cover advocates or personal relationships based on their biased opinions, and she has constantly claimed that she has a personal relationship with Lindsay Chrisley. So does that come into play?
No.
Well, I mean, in the Chrisley lawsuit, maybe, because if she's trying to protect Lindsay Chrisley as a source, and that's the state of the case law, it doesn't extend to personal friendships, then her saying she is a friend is like it can't be a confidential source at the same time. So if that's the state of the case law, then that result would imply that she would have to turn over those conversations because they can't be protected using that precedent. So I don't know the degree to which that is the state of the case law, but assuming the premise, then yeah, her journalistic shield argument for the arguments with Lindsay Chrisley wouldn't work.
But I don't think the journalistic shield arguments are even relevant to the Chrisley's argument because all right. So everybody understands the reason why most of us, MLA, Uncivil, myself, all of us believe that lawsuit is crap, is because she went on Dr. Phil and said this happened to her and filed a police report.
Yeah.
If in any defamation case, when that happens, and you're saying I just said what the police report said and what she said on Dr. Phil, you got nothing. You honestly don't have anything. So all that about journalistic, all that's just junk. That stuff for you guys to say she's trying to have it both ways. I'm a journalist, so I can, which I'm sorry, I blanked out. But she's trying to have it both ways. She's trying to say I'm a journalist, right? But yet I can say these things, and that's not the case in that situation. The journalist thing is actually hurting her, and I don't know why she's trying to continue to play that game, but it's not. And the 7M, I think 7M is going to really hurt.
Now I did take note of this issue because I'm not 100% sure on this. That she was saying some of this stuff before Dr. Phil, and I don't 100%. Okay, so yeah, because I don't think I to the extent that that's true, I don't think that was well brought out by Todd Chrisley in his motions, and if it was, I missed that point. So I don't remember reading that in any of Chrisley's stuff because obviously, if it precedes Dr. Phil, she can't rely on Dr. Phil as part of her basis for when she made the statements. So. But yeah, to the extent that that's true, she would have a problem. Now, that being said, though, there might be other public statements from Lindsay beyond Dr. Phil in other press, so there's that.
But there's all right, so I remember this, and yes, she had made some of those statements before Dr. Phil, so whoever said that, good pickup. Yeah. Problem now. Generally defamation is 2 years in Minnesota, and some of those statements were beyond the statute of limitations. So that's why, even with Lindsay Chrisley, that's why he could only pick certain statements, and you see them start like abruptly at a certain point, because statements before that, you can't sue for defamation because they ran out of time to bring the suit.
Yeah, so maybe the statements they're suing over were after Dr. Phil. Yeah. So because I don't remember that argument in the motions with Chrisley, so I'm sure they didn't do it. And VSync, I pulled up this in the background of this case. It just becomes this case. It didn't really go anywhere. It just became a euphemism, apparently more in the UK, if I understand it correctly, for a very curt dismissal letter. Basically, go screw yourselves. And so people will sometimes write, "I just refer you to the response of this case," as a way to tell someone off. So okay, noted.
Okay, I have something I think we need to clarify on not just Kurt's behalf, but in some cases on Nate's behalf. Cool. We have somebody that's saying that they hope that Kurt's going to get bit by KJ one day, and you're going to hope that she's getting her defamation. If you hope she keeps getting defamation paid for, we're so sorry he said that in front of you. Kurt and Nate are not commenting on what they personally want. They are commenting on the law and the state of her insurance. They are saying if in fact she has this insurance, and they hope she does for her own sake, that she doesn't go bankrupt for her child, that it would protect her. This is not a personal opinion. They're only evaluating things on the law, not whether they like somebody or not. So we're going to set that out.
Me and Kurt deal with this all the time. When we like again, this is like the first case we said she's got problems with. All the other ones when we say, okay, this is the reason why she's likely to win or whatever. So if she really has a problem with out of 4 cases, us saying that this one has legs, then it shows more about the person who has a problem with that than us, right?
Right, but I still, for the people that are new, we're going to put it out that this isn't personal opinions, that this is based on law and reading the law, not our feelings. It's on the facts. So let's see. Somebody wants to know, what about the fact that she admitted to Todd's lawyer she doesn't know the name of her sources from the Chrisley crew? Can they bolster her claims of things?
She has to disclose as much as she has. So she would, assuming she has to disclose it, then she would have to disclose as much as she has. She can't be forced to disclose what she doesn't know. So if it's eventually ordered to be disclosed, then we might be able to go to phone records, for example, or any other sort of evidence that would show who it came from, or at least validate that it occurred, or stuff like that. But she's like, I don't remember the name. I mean, she can't disclose what she doesn't have.
But good part
or if the person never gave the name, which also makes you wonder how they know that they were a staff person. Like,
right.
Why did you believe they were a staff person without any sort of
that's exactly what I was going to bring. Is that
factor?
If you got no evidence of who the person, then you can start getting to that negative inference of you didn't have a source because that's the first thing any newspaper would they have your name. They're like, oh, we're not going to unname you because just in case they get sued, they're going to have an in-camera review of the judges. Who is your source? This is the person's name, but they didn't want to tell us. They didn't want me to publish it. And you're like, okay. If you don't have that, then you can get a negative inference that said you didn't have a source, and it's not a problem.
Yeah.
So another
How much
question:
can these defamation suits end up costing?
We're talking about. Well, there's a when you're doing billing, right? So first you're talking about the motion to dismiss, and that's why most cases you try to get it out the motion to dismiss because you're really just responding. So you got maybe not too many hours in the response papers. You may have to speak to the other attorney. So the amount, but then when you're talking about discovery, and then you're talking about depositions, you're talking about lawyers getting paid $300 an hour, being there for maybe days at a time. We're talking about weeks, days, and then you're talking about trial where you get paid an hour before you get there, an hour after you get there, then you got to prep for trial. So you can be, I'll say this. Think about this way. Toddy Westbrook probably paid about maybe $100,000 to $150,000 for the motion to dismiss the case that she got dismissed. And if you're talking about just hours, didn't her lawyer give his hourly rate?
I think the other lawyer did. I think Brown did at one point.
Yeah, because he was trying to get the money back.
And for that one thing, it was like $20,000 or something ridiculous.
So we're talking about $50,000, and then that's why the 7M lawsuit is so crazy because if she doesn't have the insurance to go out of pocket, we could be easily talking about $100,000 to defend yourself.
Wow.
From that type of lawsuit.
I mean, like a simple motion to dismiss, you're looking at $10,000, and this for this thing is not going anywhere in the near future, and so this could get expensive, and then of course there's the damages at the end, which could get even more expensive.
Yeah. And that's where all the stuff that most people are talking about, the defamation of ULB, the defamation of Charlotte on the Web, the defamation that can all come in after if she's found liable. That can all come in to show a pattern of behavior that makes it even worse. Even though I'm not assuming they'll do that, but that could be. You could bring out all those prior bad acts.
$4.99 from Better with the Irish. I love this panel. Can we do more of this? It seems very well organized, well done. Well, to the extent that people like the stream and it is a good stream and. We've definitely had a lot of people watching. We've got 700 people watching right now. So yeah, we very well may do this again.
700 people watching this?
I'm always looking for things that people will enjoy watching.
We were up over 800 for a while, guys.
Yeah.
Shit.
So I have 2 that are kind of joined, and one kind of references L in a way. So everybody's saying that Lindsay Chrisley has made several public statements asking KJ to keep her name out of her mouth, stop referencing me, stop saying I'm doing things. And, Lindsay Chrisley has come out and said, this is harming my, mental health. This is a problem. Like, I need you to stop. And she hasn't. So everybody wants to know if she would have a claim for IIED, or, in the case with Elle, that cease and desist or stop saying, it's not true. Can you go after this with IIED, and to show that she did this to, take someone who said, can they take what she's done to Elle and Charlotte to prove that it's an IIED, that she does have that propensity to intentionally go after people.
IIED is intentional infliction of emotional distress. For those who don't know, but for
I spent too much time with Kurt.
But for IIED, you need to have an underlying kind of tort. So you can't just say the person caused me emotional distress. If the person, because if I say, if somebody says, hey, Nate's a beautiful woman, which happens to be true, you can't cause me emotional distress for saying that, right? But if you say something that's false, that's defamatory, then since you violated the law in that way, then that can lead into the intentional infliction of emotional distress, and even a negligent infliction of emotional distress because of the underlying tort. So first, it all depends. Does she have an underlying claim of
Lindsay Chrisley would for defamation, probably.
Yeah.
But they're asking if they could tack that on.
It's possible. I think it's possible, but you would need a lot more, because somebody saying bad things about you doesn't get you defamation.
Yeah. Intentional infliction of emotional distress is a pretty hard trigger to pull. Negligent infliction of emotional distress is a lot easier, and that's a pattern. But intentional infliction, you have to show that someone did something deliberately for the purpose of causing such harm that no reasonable person could reasonably anticipate. And as I've said before, the sort of classic example, at least in my mind, for intentional infliction of emotional distress is there's a young mother who has a child. You know for an absolute fact the child is in fact fine. You go up to the young mother and tell her child is dead. That would be the kind of thing we're talking about. Like, you're not confused. You're doing it solely for the purpose of causing harm. This is a statement that is designed to cause more pain than any reasonable person could bear. You're doing it for the cruelty. That's the kind of thing we're looking for. So IIAD is a pretty hard trigger to pull as a result.
Yeah.
So, yeah.
This is an interesting one. I've seen a couple of people ask, and I think Nate could probably answer this one too, along with Kurt. People want to know if, like in a case that they can get an injunction essentially to have her temporarily barred from posting things on Instagram involving it, like 7M. Possible. If 7M can have a possible, they can file to have Instagram or social media platforms ban her temporarily or have her removed ultimately.
No, they would have to sue the social media companies for that. What they would do is you could tell that's a problem that you've had. I don't know if you guys know about the Cardi B Tasha K lawsuit. That's the problem that Cardi B is having with Tasha K, is that the court can tell Tasha K what to do, but they can't tell YouTube or Google what to do because they weren't sued. So Tasha K left up the videos, and Cardi B was like, "What the hell's going on? She left up the videos. Why can't we stop YouTube?" And they're like, "Well, YouTube, you didn't sue YouTube. You sued Tasha K." So the court, they went back to court, and then the court then enjoined Tasha K and said, "You got to now take them down, or you're going to go to jail." So that's kind of how that would work.
There you go. Any other questions, chat?
Oof. Well, I got to run real quick because I got 2 kids who are banging, who are now pushing me and telling me they want food. So
go feed them, Nate.
That time. I got to go.
You better feed them kids, Nate.
You guys know how it is. I'll see you guys later. It was great seeing you. Great seeing you again, Elle. It's always a pleasure to see your beautiful face. You too, Charlotte. Congratulations on the channel. It's going crazy. And Uncivilian Stephanie, I'm going to see you in person, and we're going to have it out. And Uncivil Law, my brother-in-law, I love you, baby. Talk to you guys soon.
Bye, Nate.
-X at me with the question in the chat.
Yeah, she might have missed it, so, ask again. We'll try to answer some questions along the way.
I'll try. Okay, Charlotte, Elle, go for it.
Whatever you guys have, it's fine.
Charlotte, go ahead.
Okay, I got a question. At what point does perjury come into play in a civil case?
Yeah, so a criminal charge of perjury out of a civil case is pretty unusual. It's rare out of a civil case. It obviously is a thing that can happen, but as with all criminal charges, it's up to the local charging official when to bring it. And First of all, of course, you have to be able to prove that it's a knowing lie, or a knowing falsehood, I should say, because that's what makes something a lie, that you know what you said is false, and you have to prove that. So, that can be difficult unto itself. And then, and so much of it is so small, it's kind of like the courts look at it as kind of like a nothing burger in a lot of the civil cases. In criminal cases, a little bit more common because people's liberty is at stake, obviously. So when people are lying and it might put someone in jail, the court that's more common. But yeah, like Emily D. Baker talked about like the one time she did it in a civil case, and she had this case with this guy who claimed that he slipped and fell on a bus or something like that. And there's video on the bus, and like they had multiple meetings with this guy, and like, okay, here's the video. Please show us on the video where this thing happened, and nothing even remotely close to that happened. Right? It's like we can see you just doing your bus thing, and it's just normal bus day, and nothing like this is happening anything close. And he just continued to persist. Oh yeah, I slipped and fell, but we have the video though. And he's just like, no, it definitely happened to me. He just wouldn't let it go. So after like the second or third time of this or something like that, that's when she finally decided to bring down the perjury hammer. Because like you saying this under oath, I'm like, look, we've got it on tape. We're trying to give you an out. You won't take it. And so that was one of, I think, her only experience with that. So you need a lot usually.
So it's like, you're lying. We know you're lying. Is this the hill you want to die on?
Yeah, a little
and they
bit.
said, yeah. Well,
Apparently.
I'm gonna say it with my whole chest. Yes, I want to die on that hill. That's what that is.
Like, okay.
Okay. So, can YouTube be sued for allowing KJ to continue on doing this?
No, Section 230 is your go-to. Communications Decency Act.
Okay,
Section
Kurt, explain that.
230. Yes, no problem. The Communications Decency Act, Section 230, says that a platform is not responsible for the content that people publish on that platform. And the platform publisher distinction has to deal with who's hosting the content versus who made the speech. So you can't really even say, for example, is Twitter a platform or publisher? Because to the best of my knowledge, Twitter itself has a Twitter account. And so Twitter, on its own homepage or on its own tweets, would be the publisher of its own content. So, that they don't get immunity in that sense. But they do get immunity for anything anyone else posts. They're not deemed to be the publisher. So, yeah, that's because we talked about republication. We talked about this issue with, I read this in a lawsuit, or I read this here, or read this there. It's like, well, or I heard this from a friend, gossiping style. It's like, oh, I heard it from a friend, and I'm repeating it. It's like, well, that could be a republication problem because of the thing, you're repeating the defamation, repeating the fact, and that could be a problem. And incidentally, this was a problem on the very early internet. There were two cases. One was AOL, and one was CompuServe. And the other company involved, it's such a nice little detail of internet history. It was Stratman Oakman, which is the case out of Wolf of Wall, the firm out of Wolf of Wall Street. If any of you seen Wolf of Wall Street, Stratman Oakman,
yeah,
that's actually a real firm. That was actually a real firm. And
yeah, that's based on a true story.
So that was a real firm. So that firm that case was based off of, and based on that guy, and Leonardo DiCaprio was playing a real guy at a real firm, for some dramatic license, I'm sure. But like that firm that was mentioned in Wolf of Wall Street, that firm was part of, maybe it was suing Prodigy. I think it might have been Prodigy and CompuServe because of how old school this is. So yeah, the court went the other way and said, yeah, they are available as a republisher. And because of Stratman Oakman, the Congress passed a law to change it. So nice little piece of history there to tie it all together. So good times.
You have a super chat, Kurt.
Oh yes, thank you. Thank you. I get distracted sometimes because I'm in my own little head. Classy Mom says, can you review the cause for defamation on the damages that need to be incurred, just the defamation itself? For example, and this is their example, not me saying it, Todd is 100% gay. Sorry if I repeat. Does only have to be a tangible loss. It has to be a reputational damage, which we ultimately will assign money to. I think you'd have a real tough time in the modern day with a claim like, so-and-so is gay. I think you'd have a tough time with that because people are generally accepting of gay people. And so I don't really think you could show, maybe if you had a specific person who's like, because their persona is really tied up in their marriage, and like this is like a huge deal, like their straightness is like a huge part of their persona, maybe in some specific example, possibly, but like even for Todd Chrisley, I don't think you're there, because I think you require even more. So I think you'd have a tough time with a claim like so and so is gay, because I think you'd have a tough time showing reputational harm in the modern era. Will Clem gives $1. Thank you very much.
So, Kurt, there's a question that's not specifically KJ or Chrisley, but I've seen it come up and somebody wants to know, so I'm going to ask it for them. They would like to know that if you find out that your lawyer might be assisting the other side, or one of your lawyers might be assisting the other side, do you have recourse for it?
All right, so I want to say a couple things about this. First of all, I want to be real careful what we mean about assisting the other side, okay? Because attorneys have a duty to their client, and part of helping their client can be, in some sense, helping the other side, because there might be some ground that would be in everyone's interest, right? And also, attorneys, at least in my view, attorneys should have at least a cordial professional relationship, and they will do each other favors, which is common. For example, like we have a deadline coming up, and like so you asked me for an extension. Now, unless it's going to cause me some significant harm because I've already booked a flight or something, like if it's nothing off my back, to extend it a week or two or whatever it is, like I'll say yes, because I'm going to need something from you, I'm sure, right? We're going to need to move something around. We're going to need to like agree to something. We're going to need to reach these like things. If we have to do everything, at arm's length through formalized process, it will slow the hell out of everything, and it will cost the client a ton more money. So it's in your interest financially and for time reasons, and people forget the time factor, because lawsuits can be extremely stressful for people involved. So to the extent that I can make it go faster, it's probably a good thing. So like us having some sort of cordial relationship and even cooperating isn't necessarily a violation of any obligation to me, and probably is in furtherance of my obligation to you. The only time you'd have a real problem is if the attorney is, for example, sharing privileged information with the other side in a way that doesn't benefit you. Like there's no reason for them to share that, because there's an implicit authorization for an attorney to provide privileged information in the furtherance of their client's goals. If you have me, I don't know, buying a piece of property and you tell me a whole bunch of things, I can relate those things for the purposes of buying the property, because otherwise how could I make it pass go? Me even going as an attorney is like, I want to buy that property. I mean, necessarily reveals something about my client, right? Because that's what they told me in confidence, but they hired me for that purpose. So obviously there's an implicit authorization. But yeah, that's the only time you could get into real trouble is for malpractice. So it depends a lot what you mean by the question, to be quite honest.
So the question, a little bit more to it, I'm trying to not make it personal, because as we all know, Kurt does not give personal legal advice on the internet, because that would give you an attorney-client relationship. So I'm trying to keep it as general. It appears that this person's lawyer went and was hired by the opposing party, and there's concern that now they work for the opposing party. Can they take information that from representing you?
No, they can't take information from representing you. And attorneys, when you're talking about a different party, you can't obviously switch sides in the same case. So that's like a no-go. You can't be on one side of the case and then be like, oh, I'm going to work for the other side in the same case. That's a total non-starter. But attorneys move around. In fact, it's actually unethical for an attorney to restrict their trade. So like, for example, an attorney couldn't agree to a settlement where it's like, okay, I'll agree to settle this, but this attorney can never sue me again. It's like, I literally can't agree to that. I can't agree to a restriction of my trade. So, you can't keep me as your client forever. So once our legal matter is done, this issue is done. If I go to work for someone, whether it's the same side or whether it's the same party or not, but as long as it's not the same matter, this is not a problem. I obviously have a continuing obligation to keep all your information secret, because everything you told me privileged is still privileged, right? So I can't reveal that information to the opposing side Not that it would really matter either way, because that matter is already disposed of, but I still couldn't reveal it. But yeah, that's not necessarily a problem. How's that for an answer?
Sure. Kurt, someone wants to know if KJ and her husband divorce and 7M or TC wins a large settlement, is he still responsible for helping her pay the debt? Because it's marital.
You mean their divorce is finalized? No. But I haven't heard any indication that seems likely to happen, unless someone knows something I don't know.
No, I think they're just wanting to see if, like, with bankruptcy, where you're not with marital assets and discharging things after bankruptcy, and you can't always go after certain marital assets.
Yeah, the court's going to want to know about all the potential liabilities as part of that, so they're going to want to know that. But if it's approved by the court, then those are now separate funds. You're suing KJ, not her husband, so probably not. I can't believe the answer would be yes if it's finally approved by a court. So that'd be what I think.
I think we have all of the other questions, unless the lovely LB or Charlotte have any. Oh, somebody says, do you think 7M has more merit? And I know we covered that earlier, but for the people that were late,
yes,
give them your one-sentence line.
I think this is the best lawsuit we've seen against KJ so far. This is the best lawsuit we've seen. 7M made a lot of very specific allegations. A lot of these are very specifically factual. I mean, there's no way to escape some of these as factual. There's just no way to get past that. In the original action, I said I thought the tortious interference stuff was a little weak and left a little bit to be desired. Katie's response, however, left a lot to be desired. It was overall very conclusory. It's just kind of stating things. Oh, they're a public person. Why? Oh, we have sources. Who? Some of these are protected by good faith or fair report privilege. Which? Oh, tortious interference. There's probably not tortious interference because their contract, has escape provisions. Speculation, right? So there's like nothing really here, in my humble legal opinion, in this motion to dismiss. It's all conclusory and just does not provide you any information that would let you reach these conclusions. And so I think that 7M has the best case so far because there's a lot of very specific stuff. She didn't even really do a good job, at least in the motion to dismiss, of trying to tie the business to the church, other than by saying that the pastor of the church is also the CEO of the company. But a little bit, so what? Because merely because a person has two job roles in two different works doesn't make them necessarily related. I mean, you could get there, but merely saying, oh, they're a pastor, oh, they're CEO, vis-a-vis, the church is really in control of the company. I mean, no, we need a little bit more than that, to make those kind of ties. And that's all we had here is that kind of conclusory stuff. So on the motion to dismiss, my forecast would be not so much, no. I just do not see it. I don't see how on this motion to dismiss, a court can grant a motion to dismiss. It just seems incredibly unlikely. That being the case, however, we don't know what will necessarily happen in the future. So as I think discovery will happen, and as discovery happens, it may be the case that further information will come to light that could lead to some further motion dismiss or a motion for summary judgment. So maybe, we will be able to end this before trial, but I have no reason to believe that based on the evidence thus far. So all I can say is we're going forward at this point. This may or may not conclude before the end, but I have no reason to think that right now.
Okay, Kurt, someone wants to know, shouldn't allegations be addressed even in an MTD? She didn't address any of the statements or allegations 7M had. Like with the Toddy MTD where she talked about J-Star, PewDiePie, and Trisha Paytas, they addressed them.
That's she didn't specifically address any of them, and there were so many of them. She's just like, oh, generally, maybe a lot of them are this, a lot of them are that. I'm like, no, I need you to be a lot more specific than that, I mean, again, you can make affirmative defenses on a motion to dismiss. So it's not absurd that she could bring something like, we'll take everything you say as true, Todd, But if Katie can bring enough stuff together in her motion to dismiss to prove some affirmative defenses, they can consider that on the motion to dismiss. But there's nothing here for the court to latch onto. Is in this 12-page document. I'm just not seeing it. I feel pretty confident if I were 7M right about now.
We have KJ says because 7M gives cars to its dancers, they're a cult. Does that make them a cult?
I don't think you can conclude that because someone gives someone a car, it's part of a cult. I think you might need a little bit more to show a relationship between those two things. I think that the fact they give cars is not particularly supportive of the argument they're a cult. No.
Is Charlotte providing everybody with coffee, proving that we have Charlotte's cult of coffee?
Gotta have your culty coffee. Got to.
Okay,
And the haircut. I have a question. Now that Katie has withdrawn her motion to dismiss in the Todd Chrisley lawsuit, what's next? Or is nothing going to happen until, July?
Well, what's next, I suppose, is her counterclaims. She has 20 days to file whatever she wants to file here. And, then there will be responsive periods to that. So, it buys her more time in that respect. As to the discovery issues, I can't begin to speak about that. That's why I'm slightly surprised that the court didn't have a hearing, because there seems to be some discovery issues and it would have been a good opportunity to try to deal with that. But okay, whatever. So they're going to continue having a discovery fight for the indefinite future. And she buys herself some more time because she gets 20 days and they'll get a period of response, and there'll probably be some back and forth over that. So that's probably what happens next. And then they're going to file. They'll file a motion to dismiss, obviously. Well, I can't say that for sure, obviously, but one would reasonably expect that, Todd Chrisley would file a motion to dismiss, and we can assess that for its validity. And then, of course, we flip everything around, right? Because now all presumptions will go in favor of Katie Joy because she's the plaintiff for the purposes of that thing. So, all the things she says is true, and now we'll have to assess it, whether or not it can overcome the differences and blah, blah, blah. But yeah, that's what you'd presume to happen next. So we'll see.
Okay,
Gotcha.
well, I'm going to say goodnight for now. It's been 2 hours.
Guys. Should be good content for you guys going forward on the drama
It
channel.
should be, yeah.
And the
should
7M
be.
thing looks like it'll be good content for you going forward, because doesn't look. I don't think this is going anywhere in the near future.
No, I don't think it's going away either.
Yeah.
I'm going to say goodnight for now.
Someone
But
just mentioned in the chat to
Okay.
check the filings.
I am right now.
Okay.
Uh-oh, we got a new filing.
I am right now. Everybody chill out.
There's been a filing since we've been talking.
I don't know.
don't
Give me a
know.
minute.
13 more to 600 likes. Please remember to like the video.
Like,
660
subscribe,
views.
become an
like this
uncivilian.
video.
Become an uncivilian.
Yeah. I don't think 7M needs the stream slippery. I don't think Charlotte needs to send this to 7M. I think their knowledge of this stream or not is not going to change anything for them. I think they're in a perfectly fine position going
Okay.
forward.
It says Soulline says dismiss granted with prejudice. On the
Okay.
7th.
I'm looking right now. Hold on.
That's what is in the
No.
chat. And then on
No.
IG,
Okay.
No
Hold
way.
on. Wait, no. Kurt, let me answer. No. So what they did is they entered right after the motion to dismiss Katie's law firm, or sorry, Katie,
yes.
because
It was
they
a proposed order. It was
Yes,
a
they entered a
proposed order.
proposed order. You explain how
course they
proposed
did.
order works.
Yes.
Can you
Okay.
explain
It was a
that?
proposed order. I was like, "There's no way on this earth." Yeah, I saw that proposed order. Yeah.
Explain
So
to them how it works.
As part of their motions, they also it's very typical for the side proposing whatever to also provide the proposed order to the court. Like, just make their life even easier. It's like, hey, court, we want you to grant this, and to make your life even easier, we've written it out for you.
All you
have
got to do
is
is sign it.
sign the bottom line.
Okay.
Right? It's super easy. It's already written. Super easy. So, it's right there for you. Super convenient. Barely a problem. So it's a proposed order. It is not an order to dismiss. You gave me a heart attack.
And Katie is like playing off this because apparently she put on her IG that her motion was granted.
What?
Yeah, that's what someone put in the
Oh, you can't.
Her motion to yank her dismissal was granted.
Yeah, I'm sure that was granted.
That's
Yeah.
the only thing that was granted.
Yeah.
I think people are conflating the two cases.
Yes.
My goodness.
Okay. Yes.
Yeah.
Okay.
I'm over here
Well,
having
You
many
made a
heart
heart
attacks.
attack.
I'm gonna say goodnight, guys. So I'll catch you all later.
All right.
Bye,
Thank you.
Stephanie.
Good times. All right, I guess we can wrap it up. We've been here 2 hours, 14 minutes, and sadly,
It was
I have
fun.
real world. I have
It
real
was
world,
fun.
Real world work to do. That I don't really want to do, but I have a drop dead date, so I have to get it in by midnight Eastern time. So I've got 7 more hours. So I've got to get to that. So remember, if you like our guests, to check out Charlotte on the Web and Allie B. I will at some point remember to add their hashtags to the thing so you can click on it. And if you like this channel, please like, comment, subscribe. You know, we'll continue covering the legal content and see how it progresses. And we'll go from there. And I really enjoyed talking with both of you.
Yes.
Thank you,
for having
Kurt.
me.
All right. Until later, my friends, I've been Uncivil Law. Cheers and goodbye.
Bye.